certain immoral activities. He forced me to that. I somehow returned back. My in-laws just filed a civil suit against me and my husband, disowning him and for permanent injury. Now the problem is I am residing in Haldwani. I'm unemployed. I'm totally dependent on my pay.
Haldwani to Karnal is not very far off. And you are a defendant, no?
No, I'm the petitioner. In civil suit,
in the civil suit, she is the defendant.
You are the defendant.
And the property is located in Karnal.
I also understand it's a civil suit, but lordship.
Sorry.
Then permit ask them to pay the traveling expenses whenever my.
I am not the husband. And plus that.
So do you want expenses?
The petition was so this is complete.
Wife, you are the wife. Transfer.
The wife follows transfer follows
Service is
services
unserved.
in fact it has gone to him the
Insufficient address. Second, also no such person.
So calculate the service of the.
That process service.
yes.
Transfer. Service is complete through trial court.
Item number 11.
Yes.
I have people responding well, if other party agrees, we could send refer the matter to mediation.
Yes, Mr. Counsel, what do you say?
Joseph, I am appearing in item number 11, Your Lordship.
He says mediation. Husband says mediation.
Mediation can be done in Jalan only, Your Lordship.
Why? Why not here in the Supreme Court?
Could appear with BC minus.
First through VC unless the mediator.
Litigation expenses may be given, my lords. Then.
Sorry.
If you have to travel, mediation.
Yes,
Supreme Court.
Otherwise, the petitioner transferred to Agra to Jabalpur. Divorce petitioners.
The only thing is that look at the counter they have filed. They have said that you are very well. You are very well.
Counter is in that election document. I think I am service. I am very job.
You are working also, na?
My father is a petitioner's father is a cancer disease. Admitted never to be not to be found. Therefore, I am seeking transfer. Election.
That's all right. Sorry. Normally we allow not, but not in this case.
We see nothing.
That is okay. We are not inclined to interfere. However, liberty to the petitioner to approach the court for.
I think one matter is pending. Maintenance pending for Jabalpur.
For having the proceedings conducted through VC, subject to convenience and orders passed by the court.
Item 13.
Subject to availability of the infrastructure and the orders passed by the court. Yes, next.
Item 15.
Yes.
Passover. This is a short Passover.
Passover.
Item 14. This matter is about 650 ml beer, Your Lordship. The same was found in my car, and I was unfortunately the owner of that. I'm grateful.
Counter there is a charge sheet.
Service is not complete. That's on the private respondent.
It's not complete.
It's not complete. It says
I am going to state here.
As per Operative report, respondent number 2 could not be served. Let fresh steps for service be taken. Service in relation to concerned assistant.
I'm so grateful. Lord's interim order to continue.
Interim to continue.
I'm so grateful.
Your Lordship. This is a case for the substance.
Yes. Service is complete. Who's for the state of Rajasthan? You just pass it over. You're there. What do you say? Okay, no problem. You file a reply.
Yes, yes.
See, for 9.5 years, he's behind bars.
It was only 2 weeks.
2 weeks. No more. It's gone.
Item 17.
So this is complete the statements. They have filed a workout.
You just pass it over.
Wait, please, Your Lordship.
Yes, please.
This matter comes up after notice here. My friends have yesterday filed a counter affidavit. So they were present here on 23rd May.
Yeah, we filed it, but I don't think the state has filed its counter affidavit at the moment.
Counter of the state is there, but
We've not been served.
State has not filed a counter, my lord. Respondent number 2, my lord, the private party, the complainant has filed.
As per the office report, they have not filed. State.
So what do you say?
Well, we are ready to argue, but the state has to be heard.
But you are the complainant.
I'm the complainant.
Why should we not grant bail?
Well, it's Lordship sees the earlier order of my lords. Order dated 23rd of, this is the impugned order. Lordship has an extra P10. The petitioners got bail earlier. We came and challenged before this court. This court set aside that order and remanded back the matter to the High Court for reconsideration because the essential ingredients of Section 21(4) of MACOCA were not considered. Now, after that, this order has been passed by the trial court. The petitioners are the main person and who had actually engaged those hired assassins and who had then shot dead the deceased. That's the husband of the respondent number 2. Lordship, may kindly have an extra P10. Which is the earlier order of this court. They were granted bail by the High Court and then we came to in the SLP. Lordship has page 232.
This one.
Lordship has page 232.
232.
It's 232, my lords. An extra P10.
Yes.
Lordship has it.
We have it.
Lordship notice.
Yes.
Para 4, it is a core contention of the appellant that the bare perusal of the impugned order itself will bring home the fact that order granting bail to respondent number 2 and 3 in case of MACOCA is an outcome of consideration akin to a mini trial.
So we had only remanded the matter.
Remanded the matter and then the trial court recalled its order, which was actually set aside and they did not grant him bail. So now it's a case where they are not being granted.
The trial court, my lord, it's the High
Court, sorry. And now they are seeking bail before my lords.
One thing is there, subject to correction.
Please, my lords.
Even while we remanded, we did not cancel their bail.
Please.
We said yes, he will continue.
See, what we are saying is that page 243, even while we remanded the matter,
right, sir,
we did not cancel his bail.
Yes, my lord said that the order granting them bail will continue till the decision and the matter be decided within 1 month. Now, this order was extended by the trial court, High Court by granting bail.
Correct.
But when we came up on the after notice matter, this court directed them to surrender. If Lordship has the last order, there was no exemption from the surrender granted. So on 30th June, they have surrendered. I believe they have filed a additional document showing the certificate of surrender. So today they are in custody. And my lords, what has happened is, it is within 3 years they have been granted bail. So Article 21 also will not apply, then it's a delay.
It is a family dispute. But
it's not exactly a family dispute, my lords. It's a case where there were property disputes.
Property dispute.
But the fact is, you cannot take the life by hired assassins in this manner. And there is lot of video, we see video capturing, which will show that A1, A2, A3 and the petitioners came out. Petitioner was taking the fruits and there is a communication between the hired SLCs and the petitioner, and I will place everything on the record.
Madam, just one. See, we are asking ourselves, there are 17 litigations pending interceding parties. He's behind bars for how long?
Malad, it was less than 3 years.
Sorry, bail was granted after 3 years and 1 month. And now, my lord, again 2 months I have been in jail. 3 years and 1 month.
3 years and 1 month, Malad.
For both the brothers. So my friend
Now,
is the wrong statement.
6 November 23, they were granted bail. They were arrested on 6th of October 2020. And then they surrendered only on the 30th of June. So 1 month now and 3 years then.
2 months now. Please have your calculation right. Sorry.
June end, only July is over.
Sorry.
To be over.
Sorry.
My colleague correct calculation.
We don't like this.
Sorry.
We are putting it to her.
I'm sorry.
You'll have your.
I'm very sorry.
Yeah?
Very sorry.
Correct her. No
Please,
difficulty.
please.
So 3 years, 1 month was before the release and 1 month now.
When this court cancelled the earlier bail,
These my lords.
remanded the other,
Right.
the earlier order, court consciously did not cancel the bail.
Well, that's quite.
Therefore, the court
And
said that please re-examine the issue. Now, in this view of the matter, we are telling you that when two warring groups
It's not a,
pertaining to
with all due respect, my lords, it's not a case of warring groups. It is a case where there is a litigation, no doubt, but you can't hire assassins to take.
allegedly.
No, allegedly, no, my lords, there is lot of evidence. If lordship is, there are emails of attacks, there are phone calls. I can place everything on record. I can find all those documents on record.
Having heard learned counsel for the parties, we will also present the record. That consider you that the attending facts and circumstances, more so, considering the earlier order passed by this court, with a earlier judgment dated so and so passed by this court, with page 240, the petitioner is entitled for.
The 2nd January 25.
Title for the relief rate for independent petition. That is, as such, we direct the petitioner to be enlarged on bail on such terms and conditions as may be expressed by the trial. Needless to add, what is the stage of?
Well, that's my respectful submission.
Charges have not been framed.
Because they are delaying the trial. In fact, the APP has filed an application.
We are saying that.
No, APP is filed and that there be for expedition of trial, but they are not.
Yeah, we are saying.
Next date of hearing is 14th August. For framing of charge.
Needless to add, framing of charge means the investigation is complete.
Yeah, charge sheet has been
One by one. We are asking.
Charge sheet has been filed, lords.
No, so it has got to our notice that Challan already stands presented. And the matter is now listed for hearing on dash
14th August.
41 for framing of charge. We direct all the parties to fully cooperate. Cooperate during trial.
Let's fix a time frame.
We are saying trial is expedited. We request the trial court to conclude the trial expeditiously.
Preferably within. Preferably not.
Expedition is good enough. We, needless to add, party shall fully cooperate. Should the trial court find the accused not to be cooperating in any manner, it shall be open for the court to take all steps.
Please.
Cancellation of bail in defiance of law.
Very grateful.
Deeply obliged.
Only for information, just to say, I surrendered on 31st May, not 30th June. And I have annexed a certificate order of the court. And also the charge sheet was filed here in 2021, more than 4 years ago.
And it's their discharge application which is pending for these 2 years, which they are dragging. I can place the orders on record.
Lordship, very good.
Item 19,
If this is SLP.
I need to take a passover.
Passover.
Great.
Passover will come immediately.
It's coming after notice, plus your lordship should notice. So, 2nd of June, let's see. Here, I'm a 19-year-old girl, and not named in the FIR, nothing against me, even in the confession, no role, nothing of the kind. Please see, lordship may see, page 2021, as far as I'm concerned.
You're not only on the basis of the confession of a co-accused.
And that too, one line that I hold it around, and 19-year-old girl,
Lordships, there's a couple of submissions. Your Lordship may have the counter affidavit which I filed. First, the charge sheet we filed in the matter. In terms of what is weighing in favor, yes, there are no criminal antecedents. I don't join issue on that. However, there are certain other aspects. It's incorrect to state that the person has no role. It's explained in detail. Your Lordships may have para 13 and para 14 of it. In terms of this, what is emerging, your Lordships, is that there is a certain element of premeditation which is involved in it. It is not as if they are not at all out of the woods in this regard.
Yeah, okay.
That's it. Yes. It then meet with your Lordship's pleasure to formulate the order in terms of how your Lordship to formulate it. The item 18.
That is the usual order.
Right.
In every case, it goes.
And I stand corrected. I'm grateful.
Applies rules.
My lord, the petitioner is in jail for almost 3 years.
Recovery. Bail.
So the co-accused will be granted bail, they will seizure from them.
Bail.
Was it in item number 17, I was there for the respondent.
Have your breath.
I'm so sorry.
No, you don't have to be sorry.
I was in item number 7 for the respondent. 17.
Passover.
We are item 22 now.
So one of that's passover.
We really don't know.
My Lord's in item 21 seeking a Passover.
Passover.
Lords, if I may, I'm appealing to the state. We're seeking time to file counter affidavit.
We are granting bail.
Lord, it's a 75 lakh. He's a government officer.
It is not a recovery. It is disproportionate.
Please, Lord,
Disproportionate to the extent of 36%.
If I may submit, Lord, he has appeared before the IO on one date and he has not provided exactly the.
They continue to cooperate. That's a part of the order. Gentlemen, it is not a case of recovery. It is a case of disproportionate asset. It is 36% of 75 lakhs.
Grateful, my Lord. Grateful.
Item 23.
What is your good name?
My name is Siddharth Raja.
Tell your senior, you argued very well and you got an order.
Grateful.
23. 23.
Trial is going on below.
Who's there?
My lord, there are 3
Who's the petitioner?
NDPS cases. I am for the
3
state.
antecedents are there.
Opposing me.
One is NDPS. We'll pass over. Sorry. Pass over. Pass over.
Wait, please allow. All police witnesses.
It's a heroin.
All
60 grams.
well, all police witnesses.
अच्छा एक काम करिएगा नेट सर्च करिएगा कोर्ट के अंदर फोन तो चलता है ना व्हाट इज द कॉस्ट ऑफ द कॉन्ट्राबैंड रिकवर्ड फ्रॉम
It's around 1.5 lakh.
Huh?
1.5 lakh rupees.
only
1.5 lakh. 230 gram heroin.
No, this is not actually heroin. No, this is smack that they sell. No, this is
no
Heroin everywhere it is written.
well, all the police witnesses were in this. Because one they have not supported their own game.
sorry
No, your Lordship, then will let me just place my plan. No,
you have a right you have a right we have a duty
But you must correct yourself. Heroin is not that cheap. Though I have never tried, but
no, they're not selling heroin. No, may I just
अच्छा, what does it look like ये तो बता दो
no, that also no, the police officers themselves no, they say
what does it look like
actually should be white powdered substances. May I just say that now there are two main arguments for it. One was
How do you
that
consume heroin? You smoke it or do you snuff
it has to
it?
be sniffed, or it can be diluted and taken through an injection. That is also because some people addicts.
Urta Punjab used it. So that was heroin.
May I just place one? Now what has happened was
Where do you come from?
Himachal.
You know what is happening in Himachal now? You know that, no?
It's coming in from Punjab.
गिरता हिमाचल
गिरता हिमाचल हो गया. Worst.
If they could have just picked.
Worst.
If they could have
Himachal was a supplier. Now it is a consumer.
Only because they did not contain themselves to Cheras law. Had it only been Cheras law, it would not have been this bad. Because of this synthetic drug which is coming in from Punjab, the entire state is now going down the drain with all due respect.
See, there is one triangle in North India. One triangle while I was in Tripura, I saw the Burmese triangle.
May I just place me about it?
Sorry.
Let me just place
You place a recorder case.
I have just 2 points to make before you love. One was all the police witnesses, they are 4 in number. I placed those testimonies on record. They themselves in court
Have been convicted or no?
I have been convicted. So
1 minute.
Yes,
You have been convicted or no? Your appeal is pending or no?
Pending.
What is the sentence?
10 years.
10 years. You have undergone only 2 years.
2 years, 3 months. Yes.
Telling you. So you tell us what is that special circumstance for us to suspend?
All police witnesses, 5 police witnesses have placed their testimony. They categorically say that the contraband which they recovered is not what was produced before the police. Not at all. Well, they've categorically said, all 5 of them. And they said that they have not complied with the mandatory provision.
It's a good case for Kuti.
May I just then withdraw it? I'll have a
You
bail.
want to withdraw, you withdraw. We have no difficulty. After arguing for some time, we come to the court. वो जो कल withdraw हमने किया है, कल वो था वो है जुर्म वाला.
56.
उसमें ये after arguing for some time.
Item 25.
May please your lordship. It is a small piece of land, my lords, and I am in continuous position since 1950, my lords. There are entries to the effect, my lords, from
The thing is
1956.
your adverse possession plea has not been accepted.
My lords,
So therefore you tell us concurrently both the courts are going to be done.
my lords, both the courts are held against me, however, my
We
lords,
are asking you, you are the plaintiff.
my lords, I am,
Trial court framed issues, page 42,
my lords,
and you were not able to prove your title.
with this,
One, even adverse possession.
my lords.
was
If your
not-
lordship may kindly have, my lords, kindly have the record, my lords, the Khasra entries for the period 1956 to 1988 records my position as well as my name, my lords.
But adverse possession plea, I have to prove that, sir. Thank you. And
My lords, even today I am in position, my lords. Even today I am in position, my lords.
Reverse possession against state.
My lords, even today I am in position.
Your suit is not maintainable.
With this.
Per se, it is not maintainable. You have not approached the subdivisional officer.
My lords, my name was recorded in the year 1978.
Only because your name is recorded, you cannot get a title.
My lords,
Again, government.
then my lords, observe
He is
that I may not be dispossessed without due process.
No, no,
of
no.
law, my lords. I am still in possession. My house is there, my lords.
Item 46.
Update.
Item 46 is there, you just pass it.
Item 47.
Passover? Is Garima Shilma there?
Passover 7.
In fact, now, as I understand according to my instructions, the respondent has also shifted Delhi, is no more in Indore. He has filed a guardianship petition in Indore. But my
So what do you want?
can be referred to the mediation.
7.
Yes, my lord.
He says mediation.
My lord, it's fine. Mediation is fine.
Just 1 minute.
But virtually, it is.
No. We leave it to the first is virtual, then we leave it to the learning.
Yes.
So
My instructions are he has now shifted to Delhi. Otherwise, if we want VC, I have no problem.
you want what do you want?
Maybe if my client is ready to come from Ludhiana, and my instructions are
You want mediation or no?
mediation, yes.
So mediation, yes.
Passover 13.
Passover 30.
He was not here in the first one.
30?
1 But this gentleman was on bail in 2 matters in GST. The moment he gets bail, he's then brought in under this act called GC Top Law. The accused are about 18 not, and if I may just point out, the High Court does not consider this aspect that there are 2 FIRs not under GST, and those amounts are allegedly substantial. I'll just point that out. Kindly just see the counter affidavit first.
Oh, Mr. Luthra, see, 5 antecedents, that apart.
No.
1 minute. This is the count of 5 antecedents.
Yes.
And amount allegedly, your involvement is of 3,000 crores, so approximately.
I'll point out.
Yeah.
No, I understand. That's what they're saying, but your lordship is absolutely right. That's para 9 of the counter.
We appreciate that you're in custody since 2023,
Lord, may I just-
July 23. But at this stage, we are not inclined.
Can I just show your lordship not para 9 of the counter? I go by the counter.
At this stage, we are not inclined.
Can I just show your lordship 2 things not from the counter?
And the decision which was referred to last time, 2003, this Balkrishna Pandey, now considered you will not apply.
Can I
If
just
you want, we'll distinguish.
Can I just take 2 minutes and point out not just two factors to your lordship?
Why do you invite our order from us?
No, Lord,
Why are you not present this day?
But can I just show
Can give
you?
you liberty to file a fresh after some.
But can I just ask your lordship to see the counter for a minute? If your lordship still feels disinclined,
We have seen the counter, therefore only
Lord,
we
please come to page 9. Your lordship has seen page 8, but please see 9. Please see 9. In serial number 2 and 3, Lord, and page 9, I'm on bail. These are the GST offences which are the subject matter of this. This is not Lopoka, is based on early offences, these are the early ones.
Your sheet anchor of your submission, I mean, whosoever made submission last time was that delay in trial, give me bail. Framing charges not framed, give me bail.
I just
we are bound by the 3-judge bench, but we can.
Well, I understand, but I'll just show you, lordship.
We'll do that.
Well, I'm just going to show you 2 things on the counter. I won't go into the merits of my case. Just see me. Page number, internal page 9 of the counter. Number 1 is the current case, 5 crore order according to them. Now, number 2 and 3 are the cases where I'm on bail. Now, I'm not just come to page number 143 R3 of them.
First, we'll request you to please come to para 9 of their
I
counter.
made it, Lord. I'm coming to the document, not based on which they say this. Please come to R3 at page 143.
Why are you insisting on inviting an order from us?
Lord, can I just show your lordship?
We have gone through it, Mr. Luthra. We are telling you, we have consulted.
Not all I'm saying is not they have 2 witnesses against me. I leave it to your lordship. But one is only talking about not according to them that 75 lakhs or that's the only person. And that's their own document. I leave it to your lordship. Lord. Just see R3 serial number 4. They've only pointed out 1 person, Lord. There were 2 witnesses against me. Both statements have been placed on this.
Not at this stage. Not at this. Like to, we'll pass an order or you want to withdraw?
But
But then I won't press the state or withdraw. Your lordship will give me time to come back.
Seeks permission to withdraw the petition. They will be liberty to file a fresh should the trial not progress.
Wait for a moment. So it's delaying the trial, not cross-examining the witness.
Sir, charge is not free.
No, witness are not.
Charge is free.
I'm sorry.
Charge is
You are delaying the cross-examination witness.
Should the trial not.
charge.
No, you want, we can say trial expedited.
Trial has started.
No, we can say trial expedited. No, you don't want that.
This is suffice.
Yeah, I'm not able to move it.
That's a passover item number 12.
Sorry, sir.
Item of trials are all expedited.
Trial is expedited. Trial is, लिख दीजिएगा. Trial is the attending fact and so on. So we direct trial to be. Mr. Luthra. Mr. Luthra, we have said the trial is expedited. We have said trial is expedited.
That's the lordship prerogative, not though I may say not, may I just say this word then? I'm told the order sheet not, there are some delays, otherwise.
Some delay.
Delay on their part, not done. This is what I'm told, but I'll leave it to your lordship, not, I'm not.
They are saying delay is on your part, you are not cross-examining.
If it's falling to your lordship, how can I can't tell your lordship not to, it would sound preposterous for me to disagree with this because the proposition is an expedient trial for everybody. So I can't disagree with this, but I may not desire, my client may not desire it, but how can I disagree? I don't have an option. Half the time that we are asked, I think that's why it's impossible for me to make that.
Malas, I am appealing for the respondent.
Item.
Item 17.
One request, but my lord may then consider, but if trial is expected, but if they don't do it in 6 months, not then actual.
Trial to be expedited within 6 months.
And not, if not in.
Liberty to renew after 6 months.
Yes,
So the trial not here. No problem.
Malas, in this matter, Malas, we have sought information from the department, Malas. For that, 2 weeks may be granted, Malas. Malas, we will be filing counter-repetitive claims.
The petitioner has already been in prison in
11 years.
11 years.
Malas, he is having criminal antecedents also, Malas.
There is no criminal antecedent.
No, yes, Malas, yes.
The first.
Don't argue like that. Don't argue. It's not a crisscross match doing this. He's behind bars for more than 11 years.
Yes, Malas.
Now you tell us why should we not suspend it is what we are asking you. If you're ready, you argue today. Otherwise, you
File counter.
File counter.
Yes,
He is not. Sleeve match done. There was counter will first be filed within 2 weeks. Rejoinder 1 week. He is gone. We're giving a date.
Yes.
We're giving a date.
Much obliged.
Passover 19.
This is after notice matter coming up before my lords for regular bail. I am in custody from last 9 months, my lords. Charge sheet.
Bail.
Great. So sometimes we
Passover
Pleasure.
20.
May I please, lordship?
Who are you? There are 3 antecedents sir, against you. One pertaining to NDPS.
Please, lordship.
We were initially inclined, but we realized that there are 3 antecedents against you, and one pertaining to the very same, similar crime.
Lordship, what my prayer is that your custody is to more than 2 years, 5 months, lordship, and out of 13 witnesses, 5 witnesses have been examined, lordship.
Thank you.
Passover 46.
46, who's there? Yes, yes, sir, come.
For petition.
FIR number 26, then FIR number 12. And FIR number 109 also. There are 3. This is third. Yes.
46.
Where are you looking at? Where are you looking at the screen?
Passover 46.
How we have passed over 46, na?
Yes, my
Council is not ready, dismissed.
lord. My lord.
And then you're not arguing, you're looking here and there.
My lord, I was saying that.
What are we saying?
Only one incident.
No, antecedents.
If we say 3 incidents and according to you it is 1, you will look at the screen.
I am verifying that this case.
No, what is this? No, we are not inclined. Sorry.
Only one
Sorry.
incident.
You must improve your conduct in the court. This is not the way to address the court.
My lord, I am just.
Absolutely not, Mr. Counsel.
My lord, I am just.
Absolutely not. I am telling you, absolutely not. This is not the way. This is not the way to address the court. We are asking you question, you defer and you look at the screen. What is this attitude?
I apologize.
Dismissed. For the next case.
Passover 47.
Thank you. Next case, please. Yes, Miss.
Wait, please, madams. Let's have that affidavit which we have filed on record.
Yes.
Plus we have.
No, you see, affidavit we have seen.
Yes.
Is it your case? At least I could not make out such page.
Well, I will have. Well, it's the railway manual that I have attached.
Just 1 minute.
Yes.
Page 9 of that railway manual.
Yes.
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 33% by promotion.
This is the case in hand.
1 minute. And 16 point whatever by merit.
Yes.
So what you are saying is that the advertisement exceeded this 33%.
No,
Then
we are saying that this exam had to be strictly on merit basis and not seniority. That is what our case is. Whereas, let's kindly see, this says para 189, 33.13% by promotion by a process of selection from eligible group D categories of staff as specified by the zonal railways as per procedure prescribed in para 189. Now, my lord would see page 11 is para 189. So, the exam was of 100 marks. My lords would see there's a table which says written test is 85.
record of service
Yes,
is
15. So there's no seniority here. Then what happens is, my lords, may kindly come to 4. Bottom, it says all those who qualify on the basis of written test and record of service, the qualifying percentage of marks being prescribed by the general manager should be included in the panel in the order of seniority. This, my lords, kindly see just below that, 41A. The posts of commercial cum ticket clerk, so and so, under 33.13% quota, shall be filled by the process of general selection based on merit and not seniority. So,
no,
Malad,
where are you reading? Sorry.
It's 4.
Malad's page 11. And then it was clarified.
On merit, not seniority.
Yes. And the advertisement erroneously said that on seniority.
On seniority.
Yes, that was one point. Second, why this?
Mr. Shah invites our attention. Invites our attention to clause. It is clause, na?
Yes, my lord.
Clause 127.
Para 189.
127 and 189.
41A.
41A.
Yes.
Which are extracted in an under the portico.
Dismissal affidavit case, page 11.
Just one good read with annexure A3. There also, since 2014, it was clarified that it will not be seniority and only merit. Annexure A3.
Page
15, my lords.
Also, circular dated
Yes.
6 February 2014.
I know.
Annexure A3, page 15. The additional affidavit. It's argued that the selection process had to be based on merit and not seniority,
I don't know.
as was so erroneously inserted in the, which condition was erroneously inserted in the advertisement dated 8 February 2022, bracket the video of the main question. So, realizing the mistake, the authorities took action took remedial measures by issuing communication dated 2nd of August 2022, page 47.
Yes, ma'am.
In the book. And as such, the advertisement stood withdrawn. Notice needs to be let speak. Will stay.
Steve, there's a contempt. I'm obliged to this. Leave your charge. Number 49.
The paper there is there, please. Yes.
Okay. Yeah, just take you.
Yeah, Mr. Just for the information of all the members of the bar, we take up this matter for us. Should this matter collapse, then only we take up the other matters which I mentioned before. Otherwise, this matter would continue. Yes.
Wait. No, sorry.
Mr. Devan.
Yes.
Subramaniam. Both of you. Of course. Not that we are not noticing the others. One proposition of law which the courts, I court has held that it's a fundamental right. Now, on that, can you assist us first?
I'm speaking for myself, Lord. I don't think we need to even pitch it that way because.
No, but that is what the High Court has held.
Lord, if I may say so, the thrust of the judgment is that there is a rule which is an enforceable rule, and therefore there is a binding legal obligation to equate the dearness allowance payable by the state government with that of its central government. So it is not founded on a rule. And there is, of course, not an observation in relation to discrimination. And in that context, there is an allusion to fundamentals.
We only thought that.
Yes, it's not a pan-India. Well, I realized it when your lordship's order. And this is not going to be a pan-India. In fact, there are many states which adopt the same dearness allowance pattern as that of the central government, because it is based on an all-India consumer price index.
But the court has held that it's a fundamental right.
No, it's not really.
Not ipso facto. That's why.
That's the passing observation. It's not the whole.
It's not the heart of the judgment.
In fact, the first judgment which really relies upon the enforceability of the statutory rules, not pure and fundamental.
My lord, if I may address on that point, because our submissions are slightly different. We have incorporated, as my lords had asked, all the written submissions, say Mr. Bhattacharya, we received those, and those will be submitted when we begin arguments. They're photocopying now because we received some after. My lords, in that, it is quite clear that with regard to this SLP, the legal right is necessary and sufficient. The fundamental right only comes in if we are looking at the next TROPA rules of 2019. Otherwise, for this SLP, with regard to the 2009 rights, legal rights are necessary and sufficient.
Why we are saying so?
Yes.
we, as we read the judgment, and little bit knowledge that we had, and research we could do, we could not find any proposition thus far, subject to correction.
No, but it's not the decision of court, it's a fundamental right. Just mere the observation, I shall place it, Lord. The first judgment.
Allow us to.
Sorry.
Oh.
Sorry, but I could really follow.
We are only saying that it is this what really was we were really looking for, because can it be said that it's a fundamental right? It's something which was, we were pondering, we were working on, but we could not find any material on this. So we thought that maybe this.
So let me just place it. So
May I just answer?
yeah, let them answer. No, let them answer.
May I just
see also learn.
Not their argument, this to be fair, is an argument because it had fallen from my lord.
No, it has not fallen from us, it has fallen from here.
It's fallen from the High Court. It's fallen from the High Court, that's.
We are not saying.
So we have addressed that as a subsidiary argument. The crux is the legal right.
So therefore, both sides would say it is not a fundamental right. That's
not for the.
No, but we'll assist you over there as we
For the
can.
purpose of your lordship's question, the position under the constitution would be that a government servant block is necessarily controlled by rules, which are framed under the proviso to Article 309. And there are rules which regulate pay. So pay, Malone, is necessarily a matter which is governed by the rules. So Malone, if a rule is arbitrary, that's a different point altogether. But to make a claim for dearness allowance as if it was a fundamental right, I think Malone may not be it.
Thank you.
That was not our contention also before the High Court. Our contention was enforceable right.
Thank you very much. That's what we were really looking for. We were concerned about. Yes, Mr. Remand.
Yeah. So yeah.
Yes.
So may I first invite your attention to page 21, paragraph 23.
Yes.
As the pleadings indicate, it stands undisputed that due to erosion of the value of salary of government employees and non-payment of dearness allowances long, to neutralize the erosion, sustaining livelihoods of government employees has been affected to a great extent, as revealed in the report of the Fifth Pay Commission. As held above, to get dearness allowance at the rate to be calculated in terms of the All India Consumer Price Index average is now the legally enforceable right of state government employees. What we feel, apart from acquiring an enforceable legal right to get dearness allowance using the methodology of the All India Consumer Price Index, such right of employees to sustain their livelihood with human dignity has been fructified or elevated as a fundamental right as enshrined in Article 21 of the Constitution. Such right available to government employees are the main workforce behind the functioning of the government in right direction cannot be denied by the state. As observed by the Pay Commission, we are of the same view that to pay respects to the statutory rights of the government employees to get DA allowance at the rate as above, the government must generate all its resources. We feel that denial or deprivation of the legitimate claim of dearness allowance of the employees to sustain their livelihood in a dignified manner may have a demoralizing effect upon them and may in turn adversely affect the smooth functioning of government. In such backdrop, the stand taken by the state that due to financial inability is not in a position to pay dearness allowance to its employees at the rate of calculated with the methodology of a uniform All India Consumer Price Average is not acceptable. While the claim of the employees to dearness allowance is backed by statutory and fundamental rights, and the court finds that the state turns deaf ears to such rights, the court in exercise of its extraordinary judicial power may direct the state to implement such rights of employees. So I'm just placing this part of the discussion. Now just have a look at two decisions, please. We have a compilation which I'll just place over to the court and over to the court. So the first decision which I'm citing in the give to the other side, which I'm citing is it's cited as 1954 1 SEC 970, and it's corresponding to AIR 54 Supreme Court 493. You will find it at serial number 6 on the index, which we have just handed over.
Yes, please.
State of Madhya Pradesh versus GC Mandamus. Now this, if your lordship is pleased to go to page 121 of the compilation, you will notice that it is a constitution bench judgment. And may I take you now to page 123.
Yes.
Your lordship has it?
Yes.
Yes. So, mirror the opening paragraph first. The point for decision in this appeal is whether the resolution of the government of the central provinces and Virar, now Madhya Pradesh, dated 16 September 1948, fixing a scale of dearness allowance to be paid to its servants is repugnant to Article 14 of the Constitution. The circumstances under which the above resolution came to be adopted may be briefly mentioned. Consequent to the war, there was a phenomenal rise in the price of foodstuffs and of other essential commodities, and among the persons worst hit by it were government servants. As a measure of relief to them, the central and provincial governments sanctioned a grant of grain allowances to them under various resolutions passed in 1940. The scheme adopted by the central government was that its employees stationed in various provinces received the same benefit as the respective provincial government employees. But the scheme was found to be unsuitable for the employees of the central government, as the allowances granted by the provincial government were not uniform. On 10th May 1946, the central government appointed a Central Pay Commission, hereinafter referred to as the Commission, to inquire into and report on the conditions of service of its employees, with particular reference to the structure of their pay scales and standard remuneration, with the object of achieving a rationalization, simplification, and uniformity to the fullest degree possible. The commission, which was presided over by Sir S. Vardacharya, recommended by its report dated 3rd May 1947 the grant of dearness allowance on a specified scale. On 27th May 1947, the government of the central provinces and Virar appointed a pay committee, hereinafter referred to as the committee, to examine the recommendation of the Central Pay Commission and to report to the extent to which and the modification subject to which these recommendations should be accepted by the provincial government, so far as the government servants under the rule-making power of control are concerned. By its report of 22nd June 1948, the committee recommended the grant of dearness allowance on a scale which, though practically identical to that adopted by the commission in respect of salaries over rupees 400 per mention, was less than as regards salaries of rupees 400 per mention or less. These recommendations were accepted by the government by its resolution of 16 September 48. This difference in the result between the two scales not unnaturally caused considerable dissatisfaction amongst the employees concerned, and after unsuccessful attempts to get redress on the executive side, they filed through the representative, the respondent, the present application under Article 226. Now please go directly to paragraph 5 on page 125. On the first question, Rule 44 of the fundamental rules runs as follows. Subject to any restriction which the Secretary of State and Council may, by order, impose upon the powers of the Governor General in Council or the Governor General in Council, as the case may be, and to the general rule that the amount of a compensatory allowance should be regulated, that the allowance is not the whole source of profit to the recipient, a local government may grant such allowance to any government servant under its control and may make rules prescribing their amount and the conditions under which they may be drawn. Under this provision, it is a matter of discretion with the local government whether it will grant dearness allowance, and if so, how much. That being so, the prayer for Mandamus is clearly misconceived, as that would be granted only when there is in the applicant a right to compel the performance of some duty cast on the opponent. Rule 44 of the fundamental rules confers no right on the government servants to the grant of dearness allowance. It imposes no duty on the states to grant it. It merely confers a power on the state to grant compassionate allowance at its own discretion, and no mandamus can issue to compel the exercise of such power, nor indeed could any other writ or direction be issued in respect of it, as there is no right in the applicant which is capable of being protected or enforced. So we would draw on this particular observation in support of our submission that there is no fundamental right. Now there is one more decision which may be of assistance, which is at page 129 of this paper book. So this is Videsh Sanchar Nigam Limited versus Ajit Kumar, 2008, 11 SEC, page 591. And may I request you to go to paragraph 51 at page 147.
Paragraph
51.
Yes.
What is the order? So, DR is Dearness relief. Para 51. It is well settled that Dearness relief is a matter of grace to the government servants and not a vested right, and hence a claim against the government for the grant of such allowance at a particular rate is not justiciable. The grant of Dearness relief at such rates and subject to such conditions is the prerogative of the central government in terms of Rule 55A of the CCA Pension Rules 1972. Rule 44 of the Fundamental Rules for the Grant of Dearness Allowance imposed no duty on the state to grant it, and it merely confers a power on the state to grant compassionate allowance at its own discretion, and no mandamus or any other writ or direction, therefore, could be issued to compel the exercise of such a power, as there is no right in the employees which is capable of being protected or enforced. So this is, of course, as your lordships have noticed, a judgment rendered by a panel of 2 learned judges, the 2008 judgment, but it draws on, as the court has seen, the state of Madhya Pradesh judgment versus Mandamus, which is a constitutional bench judgment dating back to 1954. So we believe we would commend this approach to the court, which is to say that there is no right as such. It's a matter of discretion, and therefore a mandamus doesn't lie. Because there's no public duty or there's no duty in terms of the rule. So that's going to be the broad framework as far as our submissions are concerned as well. Now, this was our effort to answer some part of your lordship's question. Now, may I just go through the first and foremost?
No, we are in fact, to be honest, we are relieved. Both sides are not taking this plea that it is a fundamental right. We have doubts about this finding at page 21 of the High Court.
I think that's a fair assessment, judging from what they said. Yeah, and what we say. But I think we are also buttressed by this authority, which your lordship will consider in the correct perspective. But we feel that this seems to be the settled law, that this is a matter, it's obviously a matter of discretion as far as the state. That's an important prism to examine this entire case under. Because I want to now take your lordships to what they sought and what was granted by the tribunal, which has been sustained.
Please proceed your way.
Yes, I'm very grateful. Now, the petition is on record, but the application rather before the tribunal is on record. But it's not typed very accurately. So may I just request you to go to page 268 of the paper book, volume 1. So I'm first taking your lordships to the prayers, which I think are reproduced accurately here.
266 of the?
Yes, it begins at 268. It's a copy of an order. Volume 1,
This is the prayer before the tribunal.
Yes, it's elsewhere as well, but the typing is not very accurate. So I'm just reading it from here.
No problem.
This was the application.
268.
Yes.
May I place it? The application has been filed by 2 organizations of the West Bengal state government employees seeking the following amongst other relief. A. a direction upon the respondent authorities to forthwith release the 50% DNS allowance, which is due up to January 2006. This is a typing error, it should be 2016. Immediately within a period of 1 month from the date of receiving of the order. So this is one part which they asked for.
Yes.
B, a direction upon respondent authorities to immediately comply with the report of the recommendations of the 5th Pay Commission report positively and without fail within a period of 1 month from the communication of the order. C, a direction upon the respondent authorities to release the 50% of DNS allowance as the state government, without releasing the 50% DNS allowance for mere eyewash, set up the 5th Pay Commission, who recommended for 10% interim relief upon the basic pay, but no whisper about due 50% DNS allowance. And unless the court intervene into it, there may be every possibility of forfeiture of that 50% due DNS allowance, which is the penultimate goal and gain of the state government, and the applicants will suffer irreparable loss and injury. And D, the applicants pray for relief order directing the respondent authorities to grant 50% of the DNS allowance as that of the central government with arrears up to January 2015 within a period of 2 weeks from the date, it should be date of order. Now this was the framework of the prayers which they saw. So I want to just mention a couple of things. You will notice, one, there is no challenge to any rule which is extant. Number two, there is no challenge to any memorandum at all, which has been issued by the state government, explaining the scope and the amplitude. So these are two things which your lordship may just at this preliminary stage know. Now may I request the court to go to the tribunal's decision, where I want to place just a few paragraphs and then the operative directions. That you will find at page 462. Yeah, second one.
Yeah. Be volume 2.
Yes, it's volume 2. It's annexure P28.
Page
462.
It's a judgment of the tribunal.
Yes, which was eventually assailed before the High Court and sustained by the High Court. Yes.
Part 2. Yes. Yes, please.
Your lordship, sir, page 462.
Yes.
Yeah, may I jump to page 476?
Yes.
I wish to place para 25. Your lordship has, sorry.
Yes.
Para 25. Now we would like to consider the first issue, namely whether the employees of the government of West Bengal are entitled to get DA at a rate payable to the employees of the central government.
Just.
Sorry.
Yes. Yes.
So I'm just placing the question para 25, which they thereafter proceed to answer, page 476. Now we would like to consider the first issue, namely whether the employees of the government of West Bengal are entitled to get DA at a rate payable to the employees of the central government. Your lordships have that.
Yes.
Correct? Then, Manoj, with your permission, I'm skipping the some part of that discussion. Please go over to page 476.
Yes.
And about 10th line from the top, you will find there is 10th line, there is no mandate.
There is no mandate.
Yeah, so I'll just emphasize that. There is no mandate either in the statutory rules framed by the state government or in the administrative directions issued by the state government as to how Dearness allowance will be released by the state government for its employees from time to time, whereas the central government has specifically accepted the recommendations of the Sixth Pay Commission for release of DA to its employees twice a year, as on 1st January and 1st July, payable with the salary of March and September respectively for administrative convenience, with inflation neutralization being maintained at 100% at all levels. However, what is explicit from Rule 31E, these are our rules, 31E of, okay, it should be 31C of the ROPA Rules 2009, is that the state government has adopted the index with a base year of 1982 as the basis for determination of revised pay structure in terms of the 2009 rules by following an index as on 1st January 2006. It's also pertinent to point out what is implicit in Rule 31C, read with Rule 7 of the ROPA Rules 2009, along with paragraph 10 of the Memorandum of 23rd February 2009 and Memorandum of 23rd February 2009, is that the state government has followed the pattern of the central government in payment of DA to its employees at the same rate, but from different date, at least till 2010. Now let's go to the table, which is part of the impugned order on page 478. Page 478. Your Lordship has a table there.
Yes.
Correct. Now just see, I'll just explain, at least my understanding of this table. So I'll place the table, see the heading of the left-hand first column. GO number of Finance Department, Government of West Bengal. All right. So this is how they've tabulated. Then the rate of Dearness allowance released by the state government. Okay. So the rate is 2%, 6%, 9%, etc. We'll come to that. Date of effect given by the state government. So the starting point is indicated 1st April 2008, 1st June 2008. Then rate of Dearness allowance percentage released by the central government. Your Lordship has that. And here you will find that at least insofar as the tribunal sets out, all the way up to 23rd November 2010, you will find that the rates are generally the same.
Same more.
Yeah. However, the start point for the central government is the extreme right-hand column. So just have a look at that. Date of effect given by the central government. So do you have, for example, 1st July 2006? Over there, Your Lordship has that. So just see, as far as West Bengal government is concerned, it was 1st April 2008. Right, same rate, but there's a slight slack. I mean, I'm just mentioning it. This is just an analysis by the tribunal itself. Then the tribunal after 2012 doesn't set out as to what the central government rates are. It doesn't, because it mentions it on that earlier page where it says that there was a consistency. But what I want to point out on the right-hand column is please see the steady increase, because eventually our submission is going to be A, there is no fundamental right. B, there is no legal or statutory right. C, it's a matter of discretion on the part of the state, which of course, like all discretion, has to be exercised in a reasonable manner under our system of governance on the basis of relevant factors. One of the relevant factors is going to be fiscal availability of funds, priorities, because of the whole matrix of circumstances which have to be looked into. But the first thing which will strike you when you see the left-hand column is that it's not as if the state government is in repose. As far as DA is concerned, even after 35, it goes up to 45, 52, 58, 65, 75, 85, 100, 125, etc. And this has been paid. Please note that. This is in terms of our rules. This is in terms of exercise of discretion. So it's not a case where DA is not being paid. It is being paid. We'll give you those figures, etc. It is being calibrated upwards. But having regard to our abilities and our decision-making broadly. And this, in our respectful submission, this whole claim of parity, which you will find when I go to the next few paragraphs, has been expressly rejected by the tribunal. And after expressly rejecting it, I should qualify that. On my reading, they have expressly rejected it. But even after expressly rejecting it, they have brought it back in a sort of by a side door, which I don't believe is sustainable at all, which is why we went to the High Court. And of course, the High Court, as you know, has sustained it. So this table is of great value, particularly because it shows that there has been a periodic increase of DA even by the state government. And this we believe, of course, if someone comes forward to the tribunal and says that, look, this is what has been notified, but it is being denied to me, then I would respectfully submit that person has a right and the government has a corresponding duty to pay this amount. But that is the extent and scope of rights, and that's the extent to which the tribunal can go. It cannot and ought not to have done as it has over here, which is to bring in a backdoor method of parity, which is, according to us at least, not quite right. Now, yes, please.
1 minute, first. I don't want to interfere in this. Just kindly come to the 7th schedule of the Constitution. I'm going to disturb you, I'm sorry. Kindly come to the 7th schedule. And kindly come to entry 41 of list 2.
State Public Services, State Public Service Commission.
State public services are exclusively in the control of the state. All salaries, all the allowance. So the Dearness allowance is to be decided by the state because it relates to the public service of employees of the state. And therefore, each state has a different method. There are 13 states which don't follow the central government method.
I don't think so. We have any doubt about this proposition.
Therefore, the order, the central government will never apply to us because that's our domain under state public service.
Subject to what they say, and subject to correction, I don't think so. We have any doubt about it.
If you don't pull it, then the order says that you have to. I'm just pointing out there's a constitutional issue. That's all. I'm sorry. I want to.
No.
Just one.
Yes. So your lordships have now seen the table and the progressive increase over a period of time.
Yes.
That's at page 478. Now please go directly, still part of the the order which was challenged before the High Court, 484 please, 484.
Yes.
Now Manoj, I'm going to just read from here till let me place para 33 please. We have already observed that there is no mandate either under the statutory rules, which is ROPA. Because ROPA is short for Revision of Pay and Allowance Rules. So ROPA 2009 or in the administrative directions issued by the state government in the form of Memorandum of 23rd February 2009 and the second Memorandum of 23rd February 2009, and that the DA will be paid employees of the state government at a rate from the date as paid by the central government to its employees. So I want to emphasize this. At least my reading of this is that they observe that there is no mandate. No mandate. At least that's how we read it. Now let's see the next sentence. In the absence of any mandate under the statutory rules or the administrative directions, we are unable to hold that the state government employees are entitled to get DA at the rate payable to its employees by the central government. So I think this is also fairly clear, at least. But what we will show you is that despite this clarity of thought here, it becomes completely woolly-headed when we go to the operative directions. But we'll come to that. However, from the discussion made by us herein above, we can hold without hesitation that the state government employees are entitled to get DA on the basic pay at the rates to be calculated on the basis of AICPI number published from time to time by taking base year 1982. Now, where is this from? Can I continue after?
5 minutes.
Yes.
If you don't mind.
No, I don't.
Yes, please.
So, Manoj, may I take you, request you to move
Go ahead,
to
Mr.
480
Okay.
484.
We just only wanted to remind and tell him that he has to ensure applying our interim order. Only he can get that. Just tell him. Please proceed.
Sorry, I was on page 484, paragraph 33.
Yes.
And Manoj, I read the first two sentences of that paragraph to be in my favor, in the sense that it rejects the notion that whether there is a mandate for the purposes of parity between state government and central government. Now, Manoj, I'm reading on. I'm reading from the 5th line on para 33. In the absence of any mandate under the statutory rules or the administrative directions, we are unable to hold that the state government employees are entitled to get DA at a rate payable to employees by the central government. So that's clearly, Manoj, I would understand, in our favor. However, from the discussion made by us here and above, we can hold without hesitation that the state government employees are entitled to get DA on the basic pay at the rate to be calculated on the basis of AICPI number published from time to time by taking the base year 1982. It is the bounden duty of the state government to evolve norms and principles for payment of DA to its employees by calculating the same on the basis of AICPI on the basic pay fixed in terms of the ROPA Rules 2009 till the date of giving effect to the recommendations. Now it talks of the 6th Pay Commission set up by the government of West Bengal. The state government is also duty bound to pay arrears of DA to its employees after fixing the rate on the basis of AICPI number before implementation of the report of the 6th Pay Commission set up by the government of West Bengal.
Can you read this again?
Yes, I'll read it again, but I also need to follow what they are trying to say. So, Manoj, may I start with the word however? However, from the discussion made by us here and above, we can hold without hesitation that the state government employees are entitled to get DA on the basic pay at the rates to be calculated on the basis of AICPI number published from time to time by taking the base year 1982. It is the bounden duty of the state government to evolve norms and principles for payment of DA to its employees by calculating the same on the basis of AICPI on the basic pay fixed by in terms of ROPA Rules 2009 till the date of giving effect to the recommendation of the 6th Pay Commission set up by the government of West Bengal. The state government is also duty bound to pay arrears of DA to its employees after fixing the rate on the basis of AICPI number before implementation of the report of the 6th Pay Commission set up by the government of West Bengal. We would like to observe that the state government has the discretion to make payment of arrears of DA to its employees either in cash or by giving direction for depositing the same in the General Provident Fund with suitable restrictions on withdrawal of the same within the specified period of time. The first issue, whether the employees of the state government are entitled to get DA at the rate payable to its employees by the central government, is decided accordingly. So now, Manoj, let me just make an effort to try and unpack this or unravel this, or what my understanding of it is. What they say in categoric terms is, one, you are not entitled. Really, that's my reading of it. There is no equivalence between state government and central government. That's the first part of paragraph 33. Category. There is no such mandate. There is no such obligation at all as far as the parity is concerned. Because that's the question which he had framed, you remember, when the tribunal had framed, and which they are endeavoring to answer. Then they say, however, and they bring in some notion after however, to say that it's the bounden duty of the state government to evolve norms and principles. Please see this. To evolve norms and principles for payment of DA to its employees by calculating the same, and then they make a suggestion as to how DA is to be calculated. Now, this is entirely outside the province of the tribunal, completely outside. This is entirely within the state government's province, as to decide how to calculate DA, how much to give, and the methodology. Because I can understand that if there is some arbitrary methodology which is prescribed under the rules of the memorandum, someone has to challenge that. Challenge it squarely, get it struck down, and then of course the state government may have to, if it fails to sustain the methodology which it is adopting, it may have to come up with something new. But when you have an extant rule which is not challenged and which is not struck down, when you have an extant set of government memoranda from time to time, revising it, and you saw those rates going up, you have it, there is an application of mind. None of those are struck down. None of them are even challenged. We are paying in accordance with them. But then to foist through this backdoor method, whatever it means, by saying you must evolve some norms and you must evolve some principles, and you must thereafter, if there are arrears on the basis of those evolved norms and principles, pay the arrears as well. But we give you some flexibility as to how those arrears are to be paid, whether in cash or some credit to the Provident Fund. So this is at least my understanding of this. We'll come back to this because it returns in the operative directions. Now please go to page 488. So here I'm going to just in a sweep read paras 37 and 38, and then I'll come and I'll make my comments.
Please.
Para 37, page 488. This is the concluding portion. While remitting the case back to the tribunal, the division bench, this was the earlier round where we had succeeded, the division bench of the High Court has emphatically decided that the state government employees have the right to receive DA on the basic pay in terms of the ROPA Rules 2009. The tribunal was called upon to decide two issues which have been addressed by us giving our observations. The upshot of our observation is that the state government employees are entitled to get DA on the basic pay fixed in terms of the ROPA Rules 2009 at a rate to be calculated on the basis of AICPI number 1982 equals 100, published from time to time till the date of giving effect to the recommendation of the 6th Pay Commission set up by the government of West Bengal. The state government employees are also entitled to get arrears of DA on the basic pay to mitigate the loss of value of basic salary due to inflation after calculation of the rate of DA on the basis of the AICPI number 1982 equals 100 within a period of 1 year or before giving effect to the recommendation of the 6th Pay Commission, whichever is earlier. The office orders memorandums under which DA was paid to the state government employees working in so-and-so, this is in New Delhi and in Chennai, at the rate payable to the employees of the central government are struck down as arbitrary, unreasonable and violative of Article 14 of the Constitution of India. This order will not stand in the way of giving any incentive to the state government employees working in New Delhi and Chennai by way of special allowance or any other allowances to compensate the loss suffered by them for their posting at a place far away from the state of West Bengal. The function of pleadings is only to state the material facts, and it is for the court or tribunal to determine the legal result of those facts and to mold the relief in accordance with that result as decided by the federal court in Messrs. Mulji Jetha versus Khandesh Spinning, reported in AR 1950 Federal Court 83. Accordingly, we would like to give the following directions on the basis of the findings made by us. The respondent number 1, Chief Secretary to the Government of West Bengal, is directed to evolve norms and principles within a period of 3 months from the date of the order for release of DA on the basic pay of the state government employees fixed in terms of the ROPA Rules 2009 by taking into consideration inflation on the basis of AICPI number 1982 equals 100, so that DA can be paid to the state government employees at least twice in a year till the date of giving effect to the recommendation of the 6th Pay Commission by the government of West Bengal for its employees. The respondent number 1 is directed to implement the norms, principles evolved as per direction of the tribunal within a period of 6 months from the date of the order. The respondent number 1 is further directed to make payment of arrears of DA on the basic pay to the state government employees by taking into account level of inflation on the basis of the AICPI number 1982 equals 100 by following norms and principles evolved as per the directions of the tribunal within a period of 1 year from the date of the order before giving effect to the recommendation of the 6-Pay Commission set up by the government of West Bengal, whichever is earlier. The respondent number 1 is at liberty to decide the mode and manner of payment of arrears of DA to the state government employees within the period of time fixed by us. The respondent number 1 is also directed not to give effect to any effect to the office orders and memorandums issued for payment of DA to the state government employees posted in New Delhi and Chennai at a rate payable to the employees of the central government by the respondent number 1 will not make any recovery for excess payment of salary to those state government employees. The respondent number 1 is at liberty to give incentive to the state government employees working in New Delhi and Chennai by payment of special allowance or any other allowances the state government may deem fit and proper. With the above directions, the original application stands disposed of. The urgent. Now, just please note, since your Lordship has this, if you can just go to the fourth last line on page 489. Beginning, the respondent number 1 is also directed not to give effect. Your Lordship has that?
Yes.
Right. So that portion till the end of paragraph 38, end of para 38, we are not challenging. We have accepted it, right, wrong, good, bad, as far as those Delhi memorandums and Chennai memorandums are concerned. So that need not trouble this court. What we are really concerned about is the operative directions, which your Lordship will find beginning with about 7th line in para 38. The respondent number 1, Chief Secretary of the Government of West Bengal, is directed to evolve. Your Lordship has that. From that until ending with the words employees within a period of time fixed by us. This is really the problem area as far as we are concerned. Now let me just make an effort to try and understand what the directions are. The directions, according to us, first and foremost, they do not, and this is very important, they do not upset the scheme under 2009 ROPA rules. That's the first point. They don't say this is bad, this is to be nothing. So the ROPA rules have full force and continue to have full force. Second, on our understanding, they do not disturb any of the memorandums issued pursuant to these ROPA rules either. I have told your Lordship, as far as Delhi and Chennai is concerned, those memorandums struck down, that doesn't trouble you. But as far as that earlier portion is concerned, neither are the rules struck down, nor are the memoranda even touched. However, they introduce 2-3 notions. The first notion which they introduce is, which your Lordship will find, an obligation to evolve norms and principles. Now, what are these norms and principles? I already have rules. I already have government more. So they introduce this notion is directed to evolve norms and principles. Then they seem to suggest, going through the rest of the thing, that that base figure which is provided in ROPA is also required to be shifted under these new norms, etc. And payments are then to be made twice a year until the 6th Pay Commission, which is lies in the future, comes into force or whatever is earlier. So in short, this is an exercise without finding any fault with the existing regulations, directing legislation to take place because they want a new law for the purposes of bringing in parity. That's the long and short of it. Because you saw that they trace in that table. They hold that there can't be parity. But then through the back door, they introduce this direction and obligation to revise without finding any infirmity. So the obligation is not a public duty to pay under some rule which we have been deficient in doing. That's one thing. That look, you have this rule, you promised this DA, but you're failing in your public duty by not following up with your own norms and rules. That's one thing. No, that's not the direction. The direction is revise. Come up with something new and pursuant to that something new which they want to have, in parity with the central government, they bring back exactly the requirement of the central government rule. So that is what we are really agreed by. Now, before I take your lordships to the rules, can I just state one or two things? First is we are concerned with the period 1st April 2008
1st April
till 31st December 2019.
Beg your pardon?
1/4/2008 to 31/12/2019, which is the period covered by the West Bengal 5th Pay Commission and the ROPA rules of 2009. Now please go to volume 1.
I'm sorry, it's the 6th week of state.
So my understanding is, my learned friend said 6th, my understanding is 5th Pay Commission, and 6th Pay Commission is the outer link, which is sometime in the future. So until that point of time, you please follow this regime. That's my understanding, but they may be correct. Now just have a look at page 124 of volume 1.
Yes.
Do your lordships have annexed your people?
Yes.
Good. Yes. So, my lords, your lordships have page 124 of first volume.
Yes.
So this you will find is titled on page 124, West Bengal Services, ROPA, Revision of Pay and Allowance Rules 2009. Your lordships have that.
Yes.
Now, before I place those rules, may I just invite attention to Article 309 of the Constitution, which is the source of power as far as these rules are concerned.
ROPA is revision of pay and allowances rule.
Yeah. Revision of pay and allowance, ROPA. The lordship, sorry, Article 309, I'll just place it.
Please.
Recruitment and conditions of service of persons serving the union or a state. I'm sorry, Constitution.
Yes, yes.
Just, could you just...
No. Yes.
So, recruitment of, and conditions of service of persons serving the union or a state. Subject to the provisions of this constitution, acts of the appropriate legislature may regulate the recruitment and conditions of service of persons appointed. No public services enforced in connection with the affairs of the union or of any state, provided that it shall be competent for the president or such person as he may direct in the case of services and posts in connection with the affairs of the union, and for the governor of a state or such person as he may direct in the case of services or posts in connection with the affairs of the state, to make rules regulating the recruitment and conditions of service of persons appointed to such services and posts until provision in this behalf is made by or under any act of the appropriate legislature under this article, and any rules so made shall have effect subject to the provisions of any such act. So this is our source of power. Now, if we may just place a few of those rules. If your lordship goes to page 126.
Yes.
The opening words, in exercise of the power conferred by the proviso to Article 309 of the Constitution, the governor is pleased hereby to make the following rules. These rules may be called the West Bengal Services Revision of Pay and Allowance Rules 2009. They shall be deemed to have come into force on the first day of January 2006. Save as otherwise provided by or under these rules, the rules shall apply to persons appointed to civil services and posts under the rule-making control of the Government of West Bengal, except members of the All India Services, the West Bengal Judicial Service, and the members of the service to whom the University Grants Commission and the All India Council of Technical Education scales of pay apply. And then unless specifically extended under express order of the government, these rules shall not apply to so-and-so. Now, if your lordship is pleased to go to Rule 3, definitions. In these rules, unless the context otherwise requires, your lordship has that. Now, please go to 3C. Now, below 3C, your lordship will find that there is a slight typing error because immediately below that is Roman 2. So may I just request you to change it to 1, 2, and 3 instead of 2, 3, and 4.
Okay.
Now, existing emoluments mean the aggregate of 1, existing basic pay, 2, dearness pay appropriate to the basic pay, and 3, dearness allowance appropriate to the basic pay plus dearness allowance pay at index average 536 with 1982 equals 100. Now, this is what our rules provide. The rule does not, this is the manner in which it is framed. I will just take you to one or two other rules. But there is no concept. So there is a scale. It's specified the exact manner in which this particular dearness allowance is to be computed. It has to be appropriate to the basic pay and appropriate to the basic pay plus dearness pay at an index average 536 of 1982 equals 100. Now, we follow this strictly and down to the T. The tribunal, as your lordship has now seen, requests us to revise, revisit, come up with something new. The rules are clear. There's no fault found with these rules at all. Where is the question? As and when the government considers it appropriate to amend these particular rules, they have a constitutional sanction which I placed before the court. If there's something wrong with these rules, it has to be struck down. But it cannot and ought not to be where you have a direction, which your lordship will recall. I'll use the exact phraseology. The respondent number 1, Chief Secretary, is directed to evolve norms and principles within a period of 3 years, 3 months from the date of this order for release of DA on the basic pay of state government employees fixed in terms of ROPA. by taking into consideration inflation on the basis of the AICPI number. Case 489. Yeah.
What is your colleague's name? What is her
Your Lordship has page, just go to page 488, volume 2.
What is her name?
Mahima.
Very vigilant, thank you. Yes.
But just go back for a moment. We keep this, we stick with the rule, but just go to page 488 for a moment.
Yes, we have it.
See the observation in para 37. The upshot of our observations is, fifth line. The upshot of our observation is that the state government employees are entitled to get DA on the basic pay fixed in terms of ROPA rules 2009. Now this is the flourish. At a rate to be calculated on the basis of the AICPI number published from time to time till the date of giving effect to the 6th pay commission set up by the government of West India. So this is the problem, published from time to time till the date of giving effect to the recommendation. Where do they get this from? Published from time to time. So there's a continuous sliding scale according to and an obligation to keep amending the base. We are following the rules strictly. We are required to follow the rules strictly. But there is no question
Takes it back to roots.
Those are the dates which I indicated to the court.
2008 to 2019.
Yes, 1st April 2008 to 31st December 2009.
If not AICPI,
Yeah.
what is the basis of your calculation?
Sorry?
What is the basis of your calculation? if not AICPI?
It's exactly this, exactly.
Tell us what is your basis of calculation of DA?
Yes.
From time to time.
Yeah, it is, my lords, as we take the base figure, if your lordship sees C, 3C, 3. Your lordship has 3C3. You have corrected 3C3, brother, at page 127.
127.
ROPA rules, brother.
Yes.
We have to follow our rules.
Yes. No, 3C3.
Yes, that's the base figure which is indexed and fixed.
It only defines the Dearness allowance and Dearness pay and Dearness allowance.
Correct. So I'll just answer the question.
What's a Dearness allowance appropriate to the basic pay plus Dearness pay at index average 536?
Correct. So I'll just explain. Then we.
And your percentage is fixed on this base.
Correct. Absolutely right.
That's what you say.
Absolutely right. So I have the statutory base is prescribed under the rules. I follow the statutory base fixed under the rules, and thereafter I have memorandums, government orders and memorandums issued from time to time, which increase the percentage on this base. So we will see that. We'll see that how it goes. That's how it progresses. But these are the rules. Now please see the expression existing emoluments. So there is a concept of the existing emoluments, and then there is a concept of DNS allowance, which is indexed on the basis of the existing allowance. Now see the existing emolument, very, very clear, means the aggregate of existing basic pay, DNS pay appropriate to the basic pay, and DNS allowance appropriate to the basic pay, plus DNS pay at index average 536. 1982 equals 100.
Where is this geo?
Yes, so there is a series of geos which we will come to once I place the rules. But just to give you an example.
When it was released,
so from
at 2% for the first time.
Yes. So
after ROPA 2009.
Yeah.
Give us that geo.
Yes. So many of them are on record, so I'll just answer that.
1692 of 23rd February 2009. Give us that geo.
Okay, so you just go to page 162.
162,
same paper book. I believe this is what your lordship is asking for.
Yeah, so that we understand your basis of release of GA and the AICPI basis. Yes.
Yeah, I just. I think what the court is putting is very pertinent. Your lordship has 162?
Yes.
So just note this. This is one of the
first one, 23rd February 2009.
Sorry, yes, 23rd February 2009. May I place this before you? And then I'll come back to the rules.
Yes.
I'll go back to the rules.
Yes.
So just see this subject, clarificatory memorandum of the West Bengal Services Revision of Pay and Allowance Rules 2009 and on allied matters dealt with by the 5th Pay Commission. In Finance Resolution dated 28 August 2008, the government constituted a pay commission, and then the remit of the pay commission is indicated. Para 2 deals with scales of pay. Paragraph 3 deals with fixation of pay in the revised pay structure. Now there is a specific paragraph, which is paragraph 10 relating to Dearness allowance. And may I take you there? It's at page 166.
Yes.
Your lordships have 166.
Yes.
So I'll just place this. Consequent upon revision of pay of government employees in accordance with the West Bengal Services Revision of Pay and Allowance Rules 2009, the Dearness allowance to which government employees is entitled from time to time since the first day of January 2006 needs to be related to pay in revised pay structure. Necessary government order in this regard has been issued with Finance Department memo dated 23rd February 2009. And that your lordship will find at page 168. Would I just take you 2 pages further? Please see last para 3. There's actually in para 2 there's a reference to rule 12 of the West Bengal Services Rules 2009 that no arrears of of pay and allowance to which any government employee may be entitled in respect of the period so and so to so and so shall be paid to the government employee. The dearness allowance admissible to a government employee needs to be related to his pay in the revised pay structure with effect from 1st April 2008 only. Accordingly, the governor is pleased to decide that the dearness allowance payable to government employees with effect from 1st April 2008 shall be as follows. So from 1st April to 31st May 2008, rate of dearness allowance per month on basic pay is 2%. Then for the next period, June to October, 6%. 1st November 2008 to 28th February 2009, 9%. 1st March to 31st March 2009, 12%. And 1st April 2009 onwards, 16%. On the basic pay, rate of dearness allowance per month on basic pay. Then overleaf, the payment of dearness allowance under this order from the dates indicated above shall be made after, sorry.
They were not getting any dearness pay at that time.
Earlier they were getting, but that's under a different set of rules, earlier rules.
No. Under the ROPA,
our rules come in 2009.
3C4.
Actually it's 3C3. Because I requested you to just make that correction.
Okay, 3 or 4.
Anyway,
Yeah, that's right.
Let us 3C3.
Yeah.
Dearness allowance appropriate to the basic pay plus dearness pay.
Yeah.
It is plus dearness pay.
Yeah.
Basic pay plus dearness pay.
Yeah.
At index average.
Of 536.
So in this para 3 of page 168, dearness pay is not mentioned. Only basic pay is mentioned. What is this difference?
Yeah. So Manoj, the earliest dearness pay gets merged with the basic pay. For the starting point.
At the time of revision, it merges.
Yes. So that's why the concept is very clear.
Yes.
Dearness allowance appropriate to the basic pay plus dearness pay at the index average of 536.
No.
So that merges for the earlier period.
Sorry. When revision takes place, the dearness allowance or dearness pay merges with the basic pay.
That's right.
Then what is the need of mentioning in dearness allowance 3C3 appropriate to the basic pay plus dearness pay? If it is already merged.
No, it will just see, it says existing emoluments means the aggregate of existing basic pay. Your Lordship will see that.
Yes.
Then dearness pay appropriate to the basic pay. Correct?
Yes.
And the third element would be dearness allowance appropriate to the basic pay plus dearness pay at the index average of 536.
It doesn't define the dearness allowance separately.
No, it doesn't seem to.
That's how it's done.
You're right.
Dearness allowance is not defined, that means.
No. It's a percentage which is notified from time to time.
Yes.
And which, in terms of which we pay.
So this formula of 536 bracket 1982
Yeah, 1982
equal to 100 is a formula for existing emoluments, not for dearness allowance. Not for dearness allowance. It is for existing emoluments.
Yes, it's for existing.
Yes, but
it is for existing.
Not exclusively for dearness allowance, but it is for existing emoluments.
Yes.
Dearness allowance is a part of emoluments.
Yes. I would agree with that.
And not independent.
Yeah.
Yes.
It's an element.
Yes, we are trying to understand.
Yes. So this is the notion of large existing emoluments which is to be taken. On this existing emoluments, the government may in its discretion, in terms of paragraph 10, please just see. Yes.
Paragraph 10 of?
At page 166, which is what I had just placed before you. 162 at 166. This is the first memorandum of 23rd February 2009. Your Lordship has that? Correct? So, it describes itself as a clarificatory memorandum on the West Bengal services, the 2009 rules, and on allied matters dealt with by the 5th Pay Commission. Correct? It deals with a large number of issues, and we are concerned primarily with paragraph 10 at page 166.
About this.
Your Lordship has that?
Yes, please.
Consequent upon revision of pay of government employees in accordance with the 2009 rules, the dearness allowance to which a government employee is entitled from time to time since 1st day of January 2006 needs to be related to pay in the revised pay structure, and a necessary government order in this regard has been issued with the Finance Department memo of 23rd February 2009. So this is moving forward. This is what the DA will be. And the DA will be as prescribed at page 168. The period is indicated and the rate of the applicable rate of dearness allowance per month on basic pay is also indicated at page 168. May I just complete this this document at
Yes,
page 168?
yes.
So please go over to 169. Your Lordships have seen the rates. The payment of dearness allowance under the order from the dates under this order from the dates indicated above shall be made after adjusting the installments of the dearness allowance already sanctioned and paid to the state government employees with effect from 1st April 2008, 1st June 2008, so and so, with a order dated so and so, respectively. The term basic pay for the purposes of calculation of dearness allowance shall mean the pay drawn in the revised pay band, including the grade pay and NPA, where admissible, but shall not include any other types of pay. In the case of employees who do not opt for a revised structure as per the West Bengal Services Revision of Pay Allowance Rules 2009, the pay shall mean basic pay in the scales of pay as per the West Bengal Revision of Pay Allowances Rules 1993, plus dearness allowance as sanctioned by the state government employees with effect from 1st April 2007 in Finance Department so and so. The dearness allowance admissible in paragraph 4 of this memorandum shall be rounded off to the nearest rupee in each case. So this is a series of memorandums. And may I take you to page 170? 170.
Yes.
So the earlier one which we saw was 23rd February 2009. Now please see what happens on 9th December 2009. Grant of dearness allowance to the state government employees and further ad hoc increase. Your Lordship has that?
Yeah.
The governor is pleased to decide that the whole-time state government employees drawing basic pay up to so and so shall draw dearness allowance at the rate of 22% with effect from December 1, 2009. So the earlier figure, which you will see last line on page 168, 16%. Your Lordship has last line on page 120, 168, 16%.
Yes.
Now, that was in February,
Yes.
with effect from April 2009, has now gone upwards to 22% at page 170. Likewise, since we are on this, please go to page 172. Just mark the third line, 27%. 6th April 2010. And with effect from April 1, 2010.
Yes.
Have your Lordships marked that? 27%?
Yes.
Yeah. Then please go to page 174. 35% from 1st December 2010. The date is 23rd November 2010. 35% with effect from December 1, 2010. Your Lordship has that. And then I'll just end with the one at page 176, which is 45%. We'll give you a table, Bharat, so that it will have all
Yes. Yes.
Yeah. Yeah.
Yes, please.
Should we hand over a table just now to the court? We've got.
It's ready, you give it, not.
Yeah, we have it. Just give it to you. Give to them. So someone has to follow the rules. The second point is my computation in terms of the rules. Sorry.
I'm not saying that don't argue your case.
No, of course not.
You argue your case, but
Yeah.
just we are trying to gather
Yes. Yeah.
the
No, yeah.
difference between this index average and AICPI.
Yeah.
Just enlighten us.
Yes.
It is not against you. We are
Yes.
just trying to understand the list. You're just trying to understand.
No, I'll endeavor to supply that. I mean, what I have understood. But just have a look at this. Please just take up this sheet, which has just been handed.
Yes, we have.
Right. Now, instead of going from memorandum to memorandum, just please see what has happened. What you will find as far as the government West Bengal is concerned, there is a periodic application of mine. Having regard to the periodic application.
Their grievance is not against this percentage.
No, their grievance at the end of the day is,
the same percentage would fetch more in terms of rupee under AICPI
Yes.
and less in terms of index.
So your lordship is
absolutely what we have understood.
No, actually, what your lordship. So what
till this time?
Yes. So let me. My understanding is also similar in the sense what the tribunal has required to be done in terms of this revision and revisiting and coming up with principles is to shift the base. I have a base.
Understood.
Sorry?
That your case is that if the rules say that it has to be on the basis of index average, tribunal should not have or could not have shifted the whole calculation to AICPI base.
Yes.
That is what Your argument is.
No, this index average of 536, just please have a look at that, page 127. 1982 is 100 rupees. So as and when this particular rule comes into force in 2009 with effect from 2006.
Mr. Diwan.
Yes.
Sorry. Finally come back to volume 2, page 484, para 33.
Yes. Para 33, yes. I'm on that.
We appreciate your submission that the tribunal could not have legislated, could not have issued a mandamus in the
legislate.
No difficult. But we are only trying to understand on what basis or how this AICPI came to the knowledge of the tribunal and what was the basis for it to give such a direction. Because you have invited our attention to the statutory provision, which is the rules, the ROPA.
Yes.
And you have invited our attention to 3C Roman 3.
Yes.
Which speaks of index average.
Yes.
So we are trying to understand what is the difference. My query
Correct.
is
That's the query.
that it speaks of index average.
Yes.
Where does this AICPI come from?
So
and what is the difference between the two? Is what we have to please maybe not. It's almost lunchtime.
Yeah.
After lunchtime.
I'll revert.
Begin.
But if I may just hazard a guess before lunch. So essentially what is the operative direction as far as I am concerned on my understanding is that the central government follows a certain methodology insofar as AICPI is concerned, including periodic revisions as far as the base figure is concerned.
We want to understand what is this concept of AICPI. Where does it come from?
All right,
and what was the basis on which the tribunal came to such that's what
I'll just supply more. Very good. I'm grateful.
We'll continue after.
वॉकिंग है या गाड़ी से?
वॉकिंग भी जा सकते हो, गाड़ी no difficulties, please continue. No difficulties. Mr. Devan, continue, please. No difficulty. There's a small matter, that's it. Not a small, but a very, yes. What do you say?
Just a human angle, my lord, if your lordship can.
He was showing no remorse at all.
My lord,
Even in the counter, he files again. He
my lord,
fixed
the
that.
lordship, my lord, doesn't.
You understand? That's why my lord says.
Always said
yes.
Some apology. We also persuaded. One sorry word. But I must tell your lordship, when he was taken to custody and produced before here and bail was granted, he has already undergone about 21 days. And then, Lord, here now, all these time.
पहले की बात है, अंडरगोन कर दीजिए. The petitioner has been sentenced to 2 months imprisonment by judgment and order dated 15/7/25. Then amicus curiae, senior counsel Mr. So-and-so, appearing as amicus curiae, pointed out that previously also, the petitioner has suffered 21 days imprisonment before being granted bail by this court. Can you point out that order?
Yes, my lord, it is there, my lord, if your lordship look at order.
With the order dated so-and-so. In the
office report
prays that a lenient view may be taken and the sentence awarded to the respondent contemner may be reduced to the period already undergone by him. In view of the submissions, learned amicus curiae has also requested that in view of the vexatious petition, vexatious matters which the contemner has been filing in this court, a restraint order may be passed to the effect that the contemner shall not be permitted to file any such fresh PIL in this court. Taking note of the submissions advanced by learned amicus curiae, we hereby reduce the sentence of 2 months simple imprisonment awarded to the contemner with the order dated 22/7/25 to the period already undergone by him. We further direct that no further public interest litigation petition filed by the respondent contemner shall be entertained in this court.
Obliged, my lord, much obliged.
We appreciate the assistance provided by learned amicus curiae to this court in these proceedings. Order to the jail concerned forthwith.
Much obliged. Your lordship magnanimity cannot say. Much obliged, much obliged.
The Lordship's kind permission, may I just mention, the Lordship should pass an order of 1st of August this Friday, Your Lordship. There is a slight typographical error in the second last paragraph. An incorrect FIR number has been mentioned. There were two FIRs, 138 and 96. 138 is by me, 96 is by complainant.
Another FIR.
Yes, sir. So para 9, Your Lordship. The crime number
Case number would be
96. Very good. Grateful, Your Lordship.
yes, please.
They just hand in a note on that specific point. Yeah. Give it to them. We have just a note, a copy is handed over. So we open by submitting that AICPI is an abbreviation for the All India Consumer Price Index. The index is published by the Labour Bureau, Shimla, which is under the Ministry of Labour and Employment, Government of India. The Labour Bureau revises the index average twice a year on 1st January and 1st June. The broad purpose of this index is to enable adjustments with respect to inflation. The expression 536 into brackets 1982 equals 100 signifies that an item that costs rupees 100 on 1st January 1982 would have an average cost of rupees 536 on 1st January 2006. Appended to this note is the AICPI index figures between 1997 and 2020. May I take you to that? So it's just appended, just please see. Page 3. Now let me just make an effort here. So the first column which you will find is the year. So it runs from 1997 all the way up to 2020, correct? Then this index as for every month is given corresponding to each year. And at the end, you will find a column titled average, rounded. Now, if you go down to the year 2005, you will find the average figure of 536. So that's the 536 figure which is as on in average for 2005. So it takes an average of all those 12 months. And it would be applicable presumably on 1st January 2006. So that's the reason why this figure is taken, and it's a static notion as far as my rules are concerned, which we'll come to. So this is how we explain it, and then you will find that the average rounded figure goes up from time to time. Now may I just return to the note. Serial number 7. The bold font figures in the last column under the heading average are the 12-month average of the monthly index figures indicated in the row. Your Lordship, sorry, I'm going back.
Yes.
Para 8, or point 8.
Yes.
The expression index average 536 appearing in Rule 31C3 of ROPA 2009 refers to the average figure corresponding to the year 2005 or as on 1/1/2006. In accordance with ROPA 2009, the state government applies the rate of dearness allowance notified from time to time as a percentage of basic pay. The notified rates are the ones in the memoranda issued by the state government. The AICPI index rates are alien to ROPA 2009, save and except only for the definition of the component of existing emoluments in Rule 31C3. The ROPA 2009 adopts a fixed point index average base figure of 536 for the purpose of calculation of the starting or existing emolument. The rules do not have a sliding scale concept of changing the index average from time to time for the purpose of fixing DA rates in the future. The rate of dearness allowance is left to the discretion of the state government, depending on various factors, including fiscal space and financial priorities. An illustration of the dearness allowance component of a state government employee with an existing basic pay of rupees 50,000 as on 1st April 2008 is set out below. So dearness allowance as on 1/1/2013, which would be at the rate of 52%, but that's from that percentage table which we have given, it would correspond to rupees 26,000. Applying the directions of the tribunal to calculate DA on the basis of AICPI number published from time to time would mean that as on 1st January 2013, the DA computation would be as follows. Dearness allowance as on 1/1/2013 would be at the rate of 80%, which is 40,000 rupees. Now this is if you depart from my static scale to a sliding scale as directed, because the tribunal has directed you have to revise. Let's just read on. The central government derives the up this table for a moment, which I handed over before lunch. You just take up that table.
Yes.
As against the date 1st January 2013 on the top part.
Just one.
Yes, I'm sorry.
Check here.
There are more copies.
Check here. It's spinning around. There's a file to. We'll share it.
So we'll give you an extra. We have a copy.
Sorry. Yes.
So as far as government of West Bengal is concerned, just please go around the 8th to the 9th column. You will find 52. And the corresponding date is 1/1/2013. Your Lordship has 52 as the rate of DA percentage.
30.
30 and 1/1/2013, and that's 52.
Yes.
If you go down to Government of India, please go down to the figure 80.
30.
And the corresponding is 1/1/2013. Correct? So just going back to the note which I was placing, if you go to point 15.
Yes.
An illustration of the dearness allowance component of a state government employee with an existing basic pay of 50,000 as on 1st April 2008. As on 1/1/2013, the dearness allowance applying the 52% would be 26,000. For us, as this is what we are paying. But applying the directions of the tribunal to calculate the DA on the basis of, now they say that you must go on the basis of AICPI, number published from time to time, would mean that as on 1st January 2013, the DA computation would be as follows, which would be 80%, which is 40,000 rupees. The Lordship has that. So that's now point 17. Please just have a look at point 17 in my note.
Yes.
The central government derives the percentage of dearness allowance immediately on the basis of and in response to the average AICPI index as published from time to time. The tribunal records also that for the central government, DA percentage increase will be the same percentage increase in AICPI, and that is paragraph 28.5, page 480 of volume 2. In substance and effect, in substance and effect, the dearness allowance percentage published by the central government is linked to and determined on the basis of the AICPI average as published from time to time. So that's the central government formula. Sorry.
Certainly.
Of course, for one is still on his legs. But how do we read? You take it that we have not read the June judgment. You take it that we have only read para 33 of the CAT judgment. How do we read this principle of ASPI into ROPA is something which we have to explain.
Shall I write
No, not
in any time.
Just keep that in. Because that is one thing. See, primarily when we started, we were concerned about more of the constitutional aspect, that is 21. In all fairness, all of you said that 21 does not apply when it comes to DA. Now we are into the nitty-gritties of whether what is going to be the DA, percentage of DA. Now, more or less on that, to begin with, we were convinced that yes, the High Court perhaps is that, but having Mr. Devan having taken us only to this limited submission, we are putting it to you. Just keep that in. That's
And I can indicate the answer. There's no great secret at all, Lord, about what should be the, as my Lord Justice
if you don't mind, please.
asked, what is the list between the parties?
Yes,
of course. Lord, the list between the parties is, my friend says that what is the rule that is 3C3, according to him, it is a static, stratified, fossilized AICP index.
Correct.
According to us, my Lord, the word index itself means it is mobile with passage. That is all.
Where do you get that from?
From the rule itself and from the pay commission. Well, in fact, what is important is that the pay commission, that is the West Bengal Pay Commission, actually said that you, the state government of West Bengal, from 1979, from times ago, have always kept in mind the AICPI index. But you, in fact, defrayed all these dearness allowance payments with considerable delay. But why don't you do one thing? Bring yourself up to date when you make the new ROPA in terms of our Commission's recommendations, and then be in line with AICPI.
But from ROPA,
yes,
whether the recommendations are binding or not, statutory or not, that's a different matter.
Yes.
But ROPA
will not signify that.
Where can you just...
Yes, straight away. That, in fact, that was the most critical question which my Lord Justice MISHRA asked about the 3C. And that is not the heart of this matter. Please take the rule that
we have it.
Yes. Please take the clauses of 3C.
Page 127
yes,
of
that's right. Please have a look at this. My Lord, existing emoluments
in the aggregate of
means the aggregate of existing basic pay. That's the first.
Correct.
The second is dearness pay appropriate to the basic pay. So, my Lord, what happens is when a revision of pay happens, there is a merger of the basic pay and the dearness allowance which existed as on the date. That is merged. And then we come to 3. 3 is important. Dearness allowance appropriate to the basic pay plus dearness pay. That is Roman 1 and Roman 2. What Roman 3 says is, how will you calculate DA? That is what was till now basic pay. You add the dearness allowance and merging. So it is Roman 1 plus Roman 2. On Roman 1 plus Roman 2, Roman 3 will be appropriate to the basic pay plus dearness pay. Now, the crucial word is at index average. 536 within brackets, 1982 is equal to 100.
Average is defined there.
No, index average.
It's not left open.
No, if it's not left open, that is the point. If it is index average, when you use the word index, it itself suggests that there will be a mobility because that factor is given within the parentheses. Now, what your lordship sees 536 within brackets, 1982 is equal to 100, shows that 1982 is equal to 100 was updated in the year 2005, which is 536. So my lord, it falls and follows the index. So now what my friend, and my lord, very astutely if I may say so, because it's not really reflected in the judgments, is about this, well, the point which was argued was, you have no rights, you have no rights. But this is a very astute point. Namely, it is stratified. That is, it is frozen in ROPA. And after that date, the index cannot move. Well, that's the contention. According to us, well, the very word index suggests mobility. And that is how this All India Consumer Price, and in fact, well, in that two-page note which my learned Mr. Divan gave, please see item 11. That is enough for me, Lord. Item para 11 of this two-page note. Please see para 11. The AI-CPI index rates are alien to the ROPA 2009. Now we'll not see the next few words. Say and except only for the definition of a component of existing emoluments in 3.1c3. So my lord, AI-CPI is not alien for 3.1c3. And AI-CPI, my lord, index. The word index is most vital, my lord. Index means it is a discoverable value from time to time.
Space, that is the base.
This is one of the lists.
But as per this chart, which
Yes.
they are showing, the index, this index average is very
Very from here to here.
Yes, yes.
And it
according to
came down
them
to
also, it's
5.6.
not static.
Yeah, exactly. my lord.
The only
Which is
thing,
that index which you will take into account? That is AIC. Sorry.
Adding to what my lord has said.
Please, please, my lord.
See, 536 as per this chart is the value, average value.
2005.
2005.
Correct, my lord.
ROPA comes into picture.
It comes in, Lord, I'll take it.
2009.
I'm grateful. Let me explain this. My lord, that figure of 536, that is 1982 is equal to 100, is for the year 2005 because, my lord, the Central Pay Commission revised the pay with effect from 2006. 1st of January 2006. That is why, my lord, this 536 becomes relevant. What the West Bengal Pay Commission said is, follow that same index, because you have followed it from 79, and, my lord, as on the date of the application of the rules, they said it will be linked to AI-CPI. And our rules, my lord, came later, that is, my lord, because the Pay Commission was set up later. That's the State Pay Commission. But really, the crux is not whether it is index.
So whether it is static or not, that is the
real. That is the new point, the novel point.
this 536 was arrived on the basis of AICPI.
AICPI. That is the point. The 536 is AICPI.
AICPI adds on 112.
just a minute.
Of AICPI adds on 1.
calculation of future increase in DA on the basis of AICPI.
Precisely, in fact, not according to us, it's embedded. In fact, that indication of the figure 536 within brackets 1982 is equal to 100 clearly shows that the index of 1982 was being updated up to 1st of January 2006. So, Malwa, the principle is that if you go by that indexation, then naturally, as and when this discovery of AICPI is done by the Bureau of Labour, that's one of the Labour Ministry, with the Ministry of Consumer Affairs, that is one of they've taken all India weighted average of what is called basket of goods and services, where there is an increase. And it is that inflation.
From ROPA.
Yes.
Can we make out anywhere from ROPA? Anywhere else in ROPA?
Yes, I can show from the evidence and ROPA itself.
No, what we have seen.
Yes.
Reading of ROPA.
Yes.
Somewhere, anywhere else other than to see.
So these two words are crucial. The use.
Mr. Patwari, just one.
Words.
We will allow each one of you. What I told you. We are trying to understand. We have not finished. We have not concluded. He still is on his legs. As and when some queries come to us, so there are two ways of proceeding. Either we keep quiet, hear them, hear you, and
responding in that.
As and when doubts would come to our mind, we would pose queries.
So very good, Manoj. I'm only responding to that.
Just one.
And if we keep quiet, there will be some constitutional interjection in between.
So the doubt has come in our mind as to whether this is static or not. So one has used the word static. Now, how do we say it is not static? Because the figure is given there. From ROPA, can we make out that yes, it is not static? Is what we are asking.
Well,
not from the definition clause.
Very well, Malone. Would your lordship kindly see Roman 3 with me?
We've seen.
Dearness allowance. Can your lordship kindly see the next word?
Appropriate to the basic.
Appropriate. Now, what does the word appropriate mean? Appropriate to the basic pay plus dearness pay, that is Roman 1 plus Roman 2, at index average 536, 1982 is equal to 100. So, Manoj, it says that dearness allowance will be calculated on the basis of this index average P. It is not indexation. And indexation is always a mobile figure based on the realities. And that is at index average. And the two words, index average.
He could have said index average as on today, which is.
Well, it is as on, in fact.
It doesn't say that.
No,
we are not the legislators. We are not.
No, I understand. There's no problem.
We are just, thinking aloud. It doesn't say.
Yes.
It fixes. It doesn't say as on.
There's another rule.
How do we read a statute? That's what we are.
No, I understand. And that is why, Malone, when you see these words, that is dearness allowance appropriate. How do you get appropriateness? By using that indexation. That indexation, Malone, in the very nature of things, is mobile. That is the point. That index, the word index itself means mobility.
Other than this.
Other than this, there are two other places in these set of rules where you will find.
Please, can you
Yes, please. If your lordships will kindly.
If you don't mind. Just
please just see, Manoj, for a moment. If your lordships will be good enough to see rule 7.
Fixation, we've seen this.
Yes, rule 7. Fixation of pay in the revised pay structure. The initial pay of a government so-and-so will be governed and on from first day shall unless so-and-so otherwise be fixed separately in respect of his substantive pay and so on. And then your lordships will find, if you come to the proviso note, the one above note 1.
Yes.
Provided the pre-revised dearness allowance appropriate to the existing non-practicing allowance admissible at index average of 536, 1982 is equal to 100 shall be added while fixing the pay in the revised pay band and the amount of non-practicing allowance at the rate so and so. So, my lord, as on the date of revision of pay, you actually employ this formula of indexation. That is to Roman 1 plus Roman 2, you add this index formula. But that index formula means that as and when it changes from 536 and it goes elsewhere in that sliding scale which was shown, then my lord, it adjusts itself. So, my lord, really the rule is one for adjustment in a pay band. My lord, in a pay band, there's an adjustment. Okay. This is the point. But I must say, my lord, it's a brilliant point taken for the first time. I have no objection. The point is a good one. It should be dealt with.
Just 1 minute to add, with your lordship's kind permission.
Yes.
Please see the same definition, dearness allowance again. Your lordship said, where does the indexation come in? Indexation comes in by the use of one expression and some words. It says dearness allowance appropriate at the basic pay plus pay at index average. Index average is a well-known expression, as Mr. Divan's note number 3 and 4 points, it showed to your lordships that this index average is given by the Labour Bureau twice a year on 1st January and 1st June. I'll just read point number 2 and 3 which he has said. This index average is published by Labour Bureau, point 3. The Labour Bureau revises the index average twice a year on 1st January and 1st June. The broad purpose of this index is to enable adjustments with respect to inflation. Therefore, dearness allowance, as we all know, has 2 components. Dearness allowance appropriate to basic pay, which is fixed when the pay revision takes place by the pay commission. And the second component of dearness allowance is dearness pay. Dearness pay is never fixed. It is always linked to inflation, which is consumer price index. So therefore, your lordship may see the plus dearness pay at index average, and we know index average comes twice a year. And why should it slide? The next 82 equal to 100 has to be given some meaning. If 1982 is equal to 100, when I'm getting pay in 2010, we will have to see this 100 also, what it is. So therefore, this 82 equal to 100 is very crucial. So the rule tells us when you are fixing dearness pay on the indexed average, you will take 1982 as 100. Then what do? You see the index average for that year and give the dearness pay. Now, therefore, 82 equal to 100 is very crucial when your lordship actually sits down to interpret the rules.
See, you want us to read into
no.
Add something to the statute. Anyhow, we look into
index. Now 2 more points. Number 1, the proof of the pudding is in the eating. On index average, they have been giving it to us. They have been giving it, but they have not been giving it twice a year. So what was our problem? Our problem was, we went to the CAT-C. They are giving it, but they give it whenever they...
We'll come back to you.
Yes.
Continue.
Okay. Nonetheless, if you just go back to my note for a moment.
Yes.
I have just completed point 17. So I'll just complete the rest of the note and then we'll move on. Point 18. In substance and effect, the DA percentage published by the central government is linked to and determined on the basis of AICPI average as published from time to time. Despite holding that there is no vested right in the state government employees for DA parity with the central government, the tribunal has brought about this parity by insisting that the state government, contrary to its own rules, adopts the methodology of the central government. The device employed by the tribunal is to make an express reference to AICPI and for DA to be revised on the basis of the AICPI number published from time to time, a notion absent in the 2009 rules. In effect, the tribunal has required a departure from the rules, amendment of the rules, by converting a static figure into a dynamic index average for the purpose of arriving at the revised dearness allowance rates. Now, this is, I just wanted to just put it court so that we are trying to respond to the court's queries. Now, let's just keep this note with you. And please go back to the ROPA rules, which your lordships will find at page 124, and we were on page 127 of the paper book, first paper book. Now, I want to just make a few comments on the definition of existing emoluments. That's where the notion of DA comes in. So please notice the expression first in Roman 3. Dearness allowance appropriate to the basic pay plus dearness pay. Now it uses the words at index average 536. So there is no sliding scale. It fixes it at index average 536. Now the bracketed portion 1982 equals 100 refers to the 1982 series. The 1982 series proceeds on the basis that what was costing 100 rupees in 1982 is to be indexed upwards on an average basis. So the rules are very clear. The rules don't take a sliding scale. Otherwise, it would have said the index average from time to time. Simple under the AI. So you will find there is no reference to the AI CPI moving index at all. One. It specifically refers to the number 536. The 536 figure is indicated at with the expression at. So it's a fixed figure. It's a static firm figure. And on the basis of this figure, of course, we keep enhancing the percentage, which we find is required or which is within our capacity, etc. This is the only way, in my respectful submission, this particular rule can be read. It abjures, it stays away from a sliding scale concept. It adopts a static concept, but the static concept is also built in along with the static concept is what your lordship saw, the memorandum which was issued and which we referred to at page 162, the 23rd February 2009 memorandum. Paragraph 10. On page 166. Consequent upon the revision of pay of government employees in accordance with the West Bengal service rules, the Dearness allowance to, yes.
Yes.
The Lordship has that Dearness allowance.
Yes, we are.
These are the modalities. And it says necessary government order in this regard has been issued with the Finance Department memo way back in 2009. And we've set out the 2009 memo at page 168. And the subsequent ones. So for all these years, this is how, this is an understanding. It's a plain language understanding. There is absolutely no question of importing words. Yeah, I can understand somebody saying that, look, this is an arbitrary manner of defining the concept. Then you strike it down. But you can't say there is no right to parity. And then you introduce parity by some fancy footwork by saying that no, please revise, please revisit, keep going back and forth. That I don't believe is a correct concept at all. And so, my lord, your lordship will see in our respectful submission, it does not leave any matter open in terms of a moving index. It fixes it because the composite expression is index average 536. Index average 536. None of the other figures are taken. So this is, my lords, the foundational and the plain language manner of reading it. Now, may I just complete this particular rule because I was just on the rule. There's not very much that I want to indicate. Mr. Subramaniam has also read page 130. Page 130 in the proviso. Here again, the expression is at index average of 536. At index average of 536. It doesn't provide for any dynamic concept over here at all. And then your lordship may just have a look. This is just a point of information. Clause 12 of Rule 12 at page 134.
Areas.
Yeah, but I mean, just a point of information. There's no dispute on this. But notwithstanding anything contained elsewhere in these rules or in any of the rules for the time being enforced, no arrears or pay to which the government employee may be entitled in respect to the period 1st January 2006 to 31st day of March 2008 shall be paid by the to the government employee. And sorry, yes. So that's where we are. Now, may I? Yeah. Now just go back for a moment to that note and the appendix to the page which we have attached to the note. That's page 3. your Lordship should have seen from the 2009 rules that it's benchmarked to 1st January 2006. So that is the rational basis for picking 536. It's specified. Otherwise, the rule might have been challenged by somebody saying, where do you get this figure from, or what's the foundation for DA? So we pegged it to this figure of 536. It eschews and doesn't adopt any of the subsequent figures at all. And therefore, my lords, the rules ought to be given full play. This is our suggestion. Now, my lords, may I just request you to take up what we handed over in the morning, which was the compilation of judgments.
Yes.
Sorry. The lordships have that compilation here. So, my lord, may I just first place before you this Jalan Trading Company. We've given the broad heading.
Yes.
On the concept of dearness allowance. So, this may be of some assistance. Just please go directly to page 3.
Yes.
So, the judgment, your lordship, begins at page 3. Your lordship has that, Justice Shah's judgment. During the pendency before the industrial court, your lordship has that. May I take you over to page 4?
Just one.
Yes, sorry.
Yes. Yes.
A synopsis of the development in the industrial law which led to the enactment of the Payment of Bonus Act will facilitate appreciation of the questions argued at the bar. Aims to receive bonus, it appears, were made by industrial employees for the first time in India in the towns of Bombay and Ahmedabad after the commencement of the First World War, when, as a result of inflationary trends, there arose considerable disparity between the living wage and the contractual remuneration earned by workmen in the textile industry. The employers paid to the workmen increase in wages initially called war bonus and later called special allowance. A committee appointed by the government of Bombay in 1922 to consider inter alia the nature and basis of these bonus payments reported that the workmen had a just claim against the employers to receive bonus, but the claim was not customary, legal, or equitable. During the Second World War, the employers in the textile industry granted cash bonus equivalent to a fraction of the actual wages, not including dearness allowance. But even this was a voluntary payment made with a view to keep labor contested. So this is perhaps a certain background as far as these bonuses and the history of those bonuses are concerned.
Yes.
Now please go to, I would just take your lordships straight away. Where is Union of India? Is Kumar? To page 4. Yes, sorry. It's page, serial number 11, which is 202.
Yes, please.
Your lordship has that 2007, 7 SCC 472, Union of India versus Arjun Jyoti Kundu.
Yes.
Now here, please go to paragraph 16.
Yes.
We had recently held in K.S. Krishnaswamy, sorry, 209.
Yes.
We had recently held in K.S. Krishnaswamy that the recommendations of pay commissions are subject to acceptance or rejection. Speaking for the bench, one of us, Justice Sema, stated, "It is well settled principle of law that recommendation of pay commission are subject to acceptance/rejection with modification of the appropriate government. So unless the government has accepted the recommendation to merge the cadres, The court cannot proceed on the basis of recommendation alone or to direct the government to accept the recommendation. In this context, we have to take note of the decisions of this court in State of West Bengal versus Kumar Mukherjee that the recommendation on pay scales are not open to judicial review, and the one in State of UP versus Ministerial Karmachari Sangh to the effect that the evaluation of typists for the purposes of pay scales must be left to the expert body. The role of the Pay Commission and that of the court has been dealt with in the decision of this court in Saurabh Chowdhury and MP Rural Agricultural Extension Officers Association. In the latter decision, it was held that by this court that pay commissions are constituted for evaluating duties and functions of the employees and the nature thereof vis-a-vis the educational qualifications therefore. Although the pay commission is an expert body, the state in its wisdom and in furtherance of its valid policy may or may not accept its recommendations. So the pay commission recommendations are not binding as far as the state government is concerned. It may accept them, it may in certain situations accept them partially, and then in others reject the app. Now please have a look at four sets of decisions which we want to place with regard to fiscal policy issues. The Lordship goes to the index. Serial numbers 2, 3, 4, and 5.
Yes.
The Lordships have that. So I just placed, my Lords, para 21 of Bengal Chemical, page 49. Is where it begins. And if your Lordship is pleased to go to page 56. In Kamani Metals and Alloys versus Workmen, it has been noted that 100% neutralization is not advisable as it will lead to inflation, and therefore Dearness allowance is often a little less than 100% neutralization. The following principles broadly emerge from the above decisions. Full neutralization is not normally given except to very lowest class of employees. The purpose of Dearness allowance being to neutralize a portion of the increase in the cost of living. It should ordinarily be on a sliding scale and provide for an increase on the rise of cost of living and decrease on a fall in the cost of living. The basis of fixation of wages and Dearness allowance is industry cum region. Employees getting the same wages should get the same Dearness allowance irrespective of whether they are working as clerks or members of subordinate staff or factory workmen. The additional financial burden, which is a revision of the wage structure or Dearness allowance, would impose upon an employer and his ability to bear such burden are very material and relevant factors to be taken into account. Having due regard to the above principles, we are satisfied in the instant case that the Tribunal has made substantially a correct approach in considering the claim for revision of Dearness allowance. Now please have a look at the second decision, which is State of Haryana, page 65 at 71.
Yes, please.
The court in the case of Secretary Finance Department versus WB Registration Service Association, dealing with the question of equation of posts and equation of salaries of government employees, made the following observation. We do not consider it necessary to traverse the case law on which reliance has been placed by counsel for the appellants, as it is well settled that equation of posts and determination of pay scales is the primary function of the executive and not the judiciary, and therefore ordinarily courts will not enter upon the task of job evaluation, which is generally left to expert bodies like the Pay Commission, etc. But that is not to say that the court has no jurisdiction and the aggrieved employees have no remedy if they are unjustly treated by arbitrary state action or inaction. Courts must, however, realize that job evaluation is both a difficult and time-consuming task, and even expert bodies having the assistance of staff and requisite expertise are found difficult to undertake, sometimes on account of want of relevant data and scales for evaluating performances of different groups of employees. This would call for a constant study of external comparisons and internal relativities on account of changing nature of job requirements. The factors which have to be kept in mind for job evaluation may include the work program, the nature of contribution, the extent of responsibility, the extent of nature of freedoms, the extent of power vested in him, the extent of his dependence on superiors, the need to coordinate with other departments. We have referred to the history of service and the effort of various bodies to reduce the total number of pay scales to a reasonable number. Such reduction is in the number of pay scales has to be achieved by resorting to broad banding of posts by placing different posts having comparable job charts in a common scale. Substantial reduction in the number of pay scales must inevitably lead to the clubbing of posts and grades which were earlier different and unequal. While doing so, care must be taken to ensure that such rationalization of pay structures does not throw up anomalies. Ordinarily, a pay structure is evolved keeping in mind several factors: method of recruitment, level at which the recruitment is made, the hierarchy of service, minimum educational, technical qualifications, avenues of promotion, the nature of duties and responsibilities, the horizontal and vertical relativities, public hearings, satisfaction level, employers' capacity to pay. We have referred to these matters in some detail only to emphasize that several factors have to be kept in view while involving the pay structure, and horizontal and vertical relativities have to be carefully balanced, keeping in mind the hierarchical arrangements, avenues of promotion. Such a carefully evolved pay structure ought not to be ordinarily disturbed, as it may upset the balance and cause avoidable ripples in other cadres as well. It is presumably for this reason that the Judicial Secretary, who has strongly recommended substantial hike in the salary of sub-registrars to the Second State Pay Commission, found it difficult to concede the demand made by the Registration Service before him in his capacity as the chairman of the Third State Pay Commission. There can therefore be no doubt that the equation of posts and equation of salaries is a complex matter which is best left to an expert body, unless there is cogent material on record to come to a firm conclusion that a grave error has crept in and fixing the pay scale for a given post and court's interference is absolutely necessary to undo the injustice. It has to be kept in mind that a claim for equal pay for equal work is not a fundamental right vested in the employee, though it is a constitutional goal to be achieved by the government. Fixation of pay and determination of parity in duties and responsibilities is a complex matter which is for the executive to discharge. While taking a decision in the matter, several relevant factors come, some of which have been noted by this court in decided cases, are to be considered, keeping in view the prevailing financial position and capacity of the state government to bear the additional liability of a revised scale of pay. It's also to be kept in mind that the priority given to different types of posts under the prevailing policies of the state government is also a relevant factor for consideration of the state government. In the context of a complex nature of the issues involved, the far-reaching consequences of the decision in the matter and its impact on the administration of the state government, courts have taken the view that ordinarily courts should not try and delve deep into administrative decisions pertaining to pay fixation and pay parity. This is not to say that the matter is not justiciable or that the courts cannot entertain any proceeding against the administrative decisions taken by government. The court should approach such matters with restraint and interfere only when they are satisfied that the decision of the government is patently irrational, unjust, and prejudicial to a section of employees, and the government, while taking the decision, has ignored factors which are material and relevant for a decision in the matter. Even in a case where the court holds that the orders passed by the government to be unsustainable, then ordinarily a direction should be given to the state government or the authority taking the decision to reconsider the matter and pass a proper order. The court should avoid giving a declaration granting a particular scale of pay and compelling the government to implement the same. As noted earlier, in the present case, the High Court has not even made an attempt to compare the nature and duties and responsibilities of two sections of employees, one in the State Secretariat and the other Central Secretariat. It has also ignored the basic principle that there are certain rules, regulations, and executive instructions issued by the employees which govern the administration of the cadre. Then please, if your lordships are pleased to go to Punjab State Cooperative Milk Producers Federation,
Yes.
which your Lordship will find at page 74, at page 97.
Yes.
Foot of the page.
Yes.
In KT Veerappa, the court upheld the principle that fixation of pay and parity in duties is the function of the executive, and financial capacity of the government is also a relevant factor to be considered, though on facts, it was held that the employees of the university were entitled to a revision of pay at par with employees of the state. It was held as under. He next contended that the fixation of pay and parity in duties, the function of the executive and financial capacity of the government, and priority given to different types of posts under the prevailing policies of the government are also relevant factors. In support of the contentions, he has placed reliance on so-and-so. However, it is also equally well settled that the court should interfere with administrative decisions pertaining to pay fixation and pay parity when they find such decisions to be unreasonable, unjust, and prejudicial to a section of employees and taken in ignorance of material and relevant factors. In the present case, it is contended that the Federation is a statutory cooperative society. The state government communicated on 1st March 1990 and 9th July 1993 the pay scales as applicable to the Punjab government employees is not to be adopted by the public sector undertakings without taking into consideration the financial health of other statutory bodies and corporations. The Federation has thus taken a conscious and concerted decision to not follow the report of the Anomaly Committee of the state government to grant revised pay scale from 1st January 1986 in view of the precarious financial condition. Moreover, financial assistance had to be availed by the Federation from the state government as well as the National Dairy Development Board. Then please have a look at, then because after that Tata Cellular, etc.
Yes.
Please go directly to para 49, which is one of the concerns which we have also taken up. Namely,
the Federation was in financial difficulties.
No, not difficulty in the sense it's a question of fiscal outlay for our part. So it has huge ramifications, Manoj. And we have therefore applied our mind and had regard to all these particular factors. So, Manoj, that's one set of decisions. Now, if your Lordship could go to another topic, which I just Yes. 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 Manoj, please see the decision at serial number 8. Mahatma Gandhi Mission versus Bharatiya Kamgar Sena.
That is about
Begins at page 148.
Central government and state government here did not be similar.
Yes. At 177. Paragraph 62.
Yes.
The fact that the Government of India accepted the recommendations of the 6th Pay Commission, for that matter any pay commission, does not either oblige the states to follow the pattern of the revised pay structure adopted by the Government of India, or create any right in favor of employees of the state or other bodies falling within the legislative authority of the state. The Government of India has no authority either under the Constitution or under any law to compel the states or instrumentalities to adopt the pay structure applicable to employees of the Government of India. I think this is a foundational principle. And in this regard, as Mr. Sibal had indicated,
the moment you bring in Mr. Sibal, we'll ask him to enforce our law.
No, we had actually done some.
Otherwise he is a start from our group.
Down to whatever your Lordship.
No, but we had said that We were only expecting that order to be implemented partly. Of course, that was subject to the outcome of the petition.
There is a
You may do that, Mr. Simple. Please ask your client.
There is a constitutional issue here.
No, what we are saying.
So that is also a constitutional issue.
No.
Yeah,
Point is, there
The
are 13 states and
implementation of the interim order is a constitutional issue.
25%
of what, Mullah?
of
There is
area.
no calculation. There is no calculation.
So you have to do the calculation.
But how can I do it? I have to devise a policy, then I have to devise a framework. That's what
You may fix any amount and give it. You may say this is lump sum amount, but give it.
That means.
They subject to the outcome. See, they are not running away.
We are also not running away.
You are, well, they have to be fair.
No, I am not disagreeing with
No,
that. That's not.
See, it's a question of.
I'm not.
So they've served you.
What's
They are
that
your
for me?
people. They've served you. They are your people. So give something.
There is no dispute on that.
Please do that. What you are saying? You may give any amount. You may give X amount, but give it. That's what we are saying. Please do that. Please persuade your clients to do that. And this is all subject to the outcome. Yes, Mr.
So, Milord, I have also just, if you see my index of authorities,
yes,
I'm not reading it because it's already quoted portion is read.
Yes.
But you recall that this Kamani Metals and Alloys at serial number 12, AIR 67, Supreme Court 1175. I read that quoted judgment from Bengal, correct? So which said that 100% neutralization of inflation may not be advisable in some circumstances, but if somebody is doing it, I don't have it, but it's another government.
Yes.
So as a point of information, the other judgment which we have placed on the same topic, your Lordship may just know, is Tamil Nadu. Yes, Tamil Nadu Electricity Board, which is at serial number 10.
This is also to the similar effect.
Yes.
Similar effect.
Rates may differ. So would your Lordship, may I just take your Lordships to it? It's at page 189. And you may go directly to page 197.
Yes.
Lordships are para 22.
The main source of finance.
The main source of finance for an electricity board is the state government. The board is run by the state government. Unless the funds are provided by the state government, the electricity board would not have sufficient funds of its own to pay the wages and the revised dearness allowance to its employees. Considering the financial difficulties which the state government was facing, the revision of dearness allowance from the above said rates at the above said rate cannot be said to be arbitrary or without any reason. While considering the grievance of wage structure or dearness allowance, the importance of considering the financial implications while providing benefits to employees has been noted by the Supreme Court in a number of judgments. The Supreme Court in Workman versus Gujarat Electricity Board, while dismissing the appeal preferred by Workman, has confirmed the view that the tribunal which rejected the demand of the employees of the board for dearness allowance, that it should be fixed with the scale prescribed by the Ahmedabad Mill Owners Association, on the ground that the board does not have the capacity to meet the additional expenditure that would have to be incurred if such demands are exceeded. The Supreme Court in Bengal Chemical has laid down that 100%, and Kamani has laid down that 100% neutralization is not advisable, as it will lead to inflation, and therefore dearness allowance is often a little less than 100% neutralization, explaining the purpose of the dearness allowance and that it should depend upon the ability of the employer to bear such burden. The Supreme Court held in Bengal Chemicals, full neutralization is not normally given except to the very lowest scale, the purpose of dearness allowance being to neutralize a portion of the increase. This is Manoj, which I had quoted and read,
yes, correct.
And that additional financial burden and so on. So Manoj, this is a consistent principle which is to be followed. Now the only point which I wanted to make was that as far as we have been able to ascertain, apart from West Bengal, the states of Kerala, Chhattisgarh, Himachal Pradesh, Karnataka, Maharashtra, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Telangana, and Tripura, which is a total of 13 out of the 27 states as well, we have been able to ascertain, do not follow the rates of DA declared by the central governments. So they have their own, we all have our, So it's a distinct scheme depending on our facts and circumstances. But I'm very grateful, but may I just commit, but we sort of divided our.
Certainly.
So if we could just have some supplementary.
5 to 7 minutes, not much.
Yes. In fact, Mr. Devana actually covered everything.
That's right, I'm not going to touch on any of the things that he has said.
Please.
I'm just apropos what fell from your lordship.
Yes.
Now, if you look at, as I was indicated earlier, you look at the 7th schedule, there are 2 entries which are very important.
Yes.
One is entry 41, state public services. So, when a finance bill is presented in the legislature, and
Yes.
appropriation is done with respect to the expenditure, with respect to salaries and all components of salary. Right? Without that, no payment can be made.
Yes.
So whether it is dearness allowance along with salary, that has to be part of the appropriation bill. Outside of that, no payment can be made.
Correct.
Then if you look at entry 43, is public debt.
Yes.
Public debt of the state, mothers, is an important factor in deciding how much money is to be disbursed.
Please.
And we have the FRBM, the Fiscal Responsibility Act, in terms of which my deficit is fixed. If I go beyond that, then consequences follow. Right? Now, public debt is exclusively in the domain of the state.
Yes.
And state public services, including all salaries, dearness allowance, all aspects, exclusively in the domain of the state.
Yes.
So the problem that arises is when the consumer price index is hoisted onto the state models. If supposing there was an act, well, let's forget this, All India price, consumer price index. Supposing there was an act of parliament, it would not pass muster saying you give this dearness allowance. It would not pass muster. So no tribunal, no authority can give a direction in law saying you to follow the All India consumer price index.
Yes.
Because it's outside the jurisdiction of the tribunal, outside the jurisdiction of the Union of India. That is why it's
even this court.
No. This court is Article 142.
No, even this court.
So, the point, your lordship asked me a very important question. Why can't you give it? Now, how will I give it? I'll have to borrow money. For borrowing money, I'll have to go to the Reserve Bank of India. The Reserve Bank of India will have to allow me, depending on my public debt. Then I'll have to go to the state legislature, pass an appropriation bill. Then the money can be disbursed. That's the procedure, mother. I can't give it just like that. So there are several aspects. And this has happened in the past. During the COVID period, no dearness allowance was paid. In Bihar, floods take place, enormous expenditure takes place. How can the state legislature even afford to pay sometimes? This happens also in Himachal Pradesh, this happens in Uttarakhand, right? A tsunami may happen, whether it's in the coastal areas. Our Manrega salaries are not paid. I have to pay them from my own pocket. There are so many issues that arise, so we have to have the fiscal space to pay them, right? Now, how can that be done by a direction of this nature? It's not possible. So when your lordships put it to me, there is a whole process that has to be followed. I can't just do it like that. Now, in the absence of that process, there can't be a direction. And actually, the whole judgment suffers from that basic error that an All India Consumer Price Index can be foisted on the state government to add it to the salary, indexed it in the way that they want.
Yeah.
Whereas as a constitutional issue, it's not possible to do that.
Yeah. Thank you. Anyone say anything?
There's a short list of dates that I prepared, and there's a
Certainly,
short amount of submissions.
Yes, Mr.
Now, the first entry, Your Lordship may only keep in mind that you had the 5th Pay Commission recommendations on 12/2/2009.
Correct.
And Malaz, they recommended sanctioning 2 installments of DA. Your Lordship will get that from page 97 to 99.
Yes.
Now, this recommendation was not implemented by us. We did not accept this recommendation. So, while framing ROPA, we didn't say that give DA twice a year, nor did we say that you adopt central government. So, that's very clear. Your Lordship gets that in the second entry.
Yes.
And Your Lordship will get that at the pages that I have mentioned.
Okay.
That ROPA did not really pick up this particular aspect.
Yes.
Now, at the first instance, Malaz, when the OA was filed, it was filed, Malaz, for implementing the recommendations of the Pay Commission. The OA was refused. And the OA was dismissed. Your Lordship will get that judgment at page 197 to page 230 of the special leave.
Yes.
Then the matter, Malaz, went back to the tribunal on a remand.
Yes.
And it is on the remand that the impugned judgment was passed on 26/7/2019.
Yes.
So I'm just, Malaz, handing over these dates, Malaz, just for the sake of clarity.
Please.
Then, Malaz, Your Lordship will just come to how the High Court dealt with this particular aspect. And the High Court proceeded on the basis that we had accepted the recommendation of the Pay Commission, which is a fundamental, Malaz, fallacy in the judgment of the High Court. If Your Lordship sees the reasoning from page 18.
You want us to read the High Court?
Yes, volume 1.
Yes.
I'm only trying to point out, Malaz, that perhaps, Malaz, with the greatest respect, the High Court actually missed the point. Just see from page 19 onwards, paragraph 18.
Paragraph?
Paragraph 18, page 19.
Okay.
The aforesaid recommendation.
Just one.
Yes.
Yes.
In fact, if Your Lordship reads from page 17.
You want us to come to page 17?
Page 17, Malaz, first paragraph 17.
Yes.
The 5th Pay Commission under chapter 10 relating to allowances amongst others reported and recommended as under.
Yes.
And then Your Lordship comes to 10.6 at page 18. It is evident from the above that the state government sanction of installment does not follow any definite pattern. It is also clear that there are delays in payments of various installments of DA. There cannot be any differences of opinion regarding the need to avoid the delays. We are of the opinion that some extra effort, the state government should be in a position to clear the backlog of loan installment, which was sanctioned by the Government of India with effect from 1st July 2008, and then fall in line with the central government pattern of sanctioning 2 installments of DA each year. We recommend this course of action. If it is done, it will mitigate a long-standing grievance of almost all the employees within our terms. The aforesaid recommendation of the 5th Pay Commission has been accepted by the government by promulgating ROPA Rules 2009. This is factually incorrect. Because A, the ROPA rules don't speak about adopting this particular basis. Secondly, there is nothing in the ROPA rules with regard to revision twice a year. As per rules, we see existing emoluments mean aggregate of one existing basic pay, Dearness pay appropriate to the basic pay, and Dearness allowance appropriate to the basic pay at index average 536/182 is equal to 100. As quoted above, the coordinate division bench in the judgment has held that the claim of the employee serving under the Government of West Bengal for Dearness allowance is based on a legally enforceable right of all the employees serving under the government of West Bengal, up to such extent of the recommendations of the Pay Commission, which has been accepted by the government of West Bengal by virtue of the provisions of Sub-Rule 1 of Rule 12 of RUPA rules, read with paragraph 10 of the clarificatory memorandum, being number such and such, dated 23rd February 2009, on the RUPA rules by the government of West Bengal Finance Department. Audit grant in paragraph 3 of the memorandum, paper number 1692, dated February 23, 2009, in the matter of withdrawal of Dearness allowance in revised pay structure under the RUPA rules 2009, issued by the government of West Bengal. This observation, as stated above, has attained finality. Therefore, we have no hesitation in our mind to hold that state government employees under the RUPA rules has acquired a legally enforceable right to get Dearness allowance at the rate to be fixed on the basis of All India Consumer Price Index as embedded in Rule 3C of the RUPA rules 2009. Now, there is nothing, my lords, in the RUPA rules of 2009, as was pointed out by my learned friend Mr. Remand, that this dynamic price index is adopted by the state under the RUPA rules. So this is, my lords, an error on the face of the record. The High Court proceeds on a basis which is factually incorrect. And then, my lords, your lordship sees further, in view of the decision on the coordinate bench, the employees under the West Bengal State Electricity Transmission Company are entitled to Dearness allowances at the rate of the central government. The learned tribunal in the impugned judgment has struck down the relevant office orders and memorandums under which DA was paid to state government employees working in Banga Bhavan in New Delhi and youth hostel at Chennai at the rate payable to the employees of the central government, holding that the orders or memorandum discriminate, offending the doctrine of equality under Article 14 of the Constitution, bearing in mind the principles enunciated by the Honorable Apex Court in its decision on the case of Nakara, reported in such and such. We hold that the classification of the state government employees working as West Bengal and the state government employees working at Delhi and Chennai, governed by the same statutory rules, is discriminatory, sounds intelligible difference, and offends the golden doctrine of equality under Article 14 of the Constitution. Since the claim of the state government employees of Dearness allowance at the rate to be calculated on the basis of All India Consumer Price Index has fructified into a legally enforceable statutory right, cite AIR 1961-86, cited by the learned Advocate General, pertaining to payment of Dearness allowance to workmen, whose conditions and services are contractual in nature under private individuals or organizations, are not applicable to the facts of the case on hand. Similarly, in view of the factual and legal scenario, the above decisions in the state of Tamil Nadu are not applicable. And then in paragraph 23 and 24, which was placed by my learned friend Mr. Devan, which I don't need to read, my lords, it is held, their lordships have come to the conclusion that grant of DA on the basis of this particular rate would be a fundamental right, with which, my lords, even the other side has said that it does not really press the point, so I don't need to read. The fundamental fallacy in the judgment of the High Court is that it assumes that the RUPA rules actually incorporate a dynamic consumer price index, which is totally wrong. In fact, Manoj, that is apparent from the definition of the word existing emolument, which freezes for a particular base at the year 2006, which is then adopted and used as a base. It doesn't say that the price index will be the same. I asked myself another question, and I'll just read two passages from the tribunals. The tribunal, on the one hand, comes to an express conclusion that you can't import central government rates to the state government for the purposes of Dearness. And it says that there is no right in this regard to do that. Now I ask myself this question, that if this is not static and if it is dynamic, what would be the ultimate end result? The ultimate end result is the same. Because if you adopt that particular rate, that is the rate which the central government adopts, and that will be the end result. So there are, Manoj, two points of contentious aspects in the order of the tribunal which I want to point out. If, my lords, we were told that you fix the norms, etc. The norms, etc. have already been fixed by us by virtue of notification. But it doesn't stop there. It says, it uses the expression time to time, and it says twice a year. which are both, my lords, practices followed by the central government. And that is, my lords, where the error has crept in the judgment of the tribe.
How has the second judge dealt, level second judge?
It's similar.
Similar.
There.
Has he given any other reasoning?
No.
No other reasoning is given?
I can place the findings.
No, we only, whether any reasoning is being.
On this aspect, there is no reason.
So there is no reason. Okay.
In fact, my lords, if your lordship sees.
No, we have understood your point.
At page 39 and 40 is, my lords, the finding.
According to you.
Of the
to you.
Lordship, please.
In view of what Mr. Diwan has argued, Mr. Singhal has argued, according to you, in view of 3C Roman 3, which is static in nature, there is error in the finding that para 33 of the tribunal as also the High Court.
Lordship,
so therefore, there no mandamus could have been issued, more so by the tribunal.
Lordship, and your lordship will just see, my lords, those two particular findings of the tribunal, the use of the expression time to time, from time to time, which your lordship will get at page.
Yes.
So, page 484, paragraph 33.
Page
484, paragraph 33. This is where the rub comes. Page 484, that's in volume 2.
Yes. Para 33.
Para 33. We have already observed.
Yes, just now.
Sorry.
Yes.
We have already observed that there is no mandate under the statutory rules, viz. ROPA Rules 2009, or in the administrative directions issued by the central government in the form of Memorandum Number 1691-F, dated 23rd February 2009, and Memorandum Number 1692-F, dated February 23, 2009, that DA will be paid to the employees by the state government at a rate from the date as paid by the central government to its employees. In the absence of any mandate under the statutory rules or the administrative direction, we are unable to hold that the state government employees are entitled to get DA at a rate payable to its employees by the central government. However, from the discussion made by us here and above, we can hold without hesitation that state government employees are entitled to get DA on the basic pay at the rate to be calculated on the basis of AICPI number published from time to time. By taking the base year 1982, that is 1982 is equal to 100. Now, this is one of the first difficulty. How do you incorporate from time to time, which means Malaz a dynamic index, which is not part of the ROPA rules at all. And further, it is a bounden duty of the state government to evolve norms, principles for payment of DA to its employees by calculating.
Anyone else this time?
Then, Malaz, my written note.
You can keep it.
I've just yes. It just encapsulates all the points.
No problem. We'll go to it. Is there, Mr. Diwan is not there, Mr. MP is there. Mr. Gopal Subramanian, we'll tell you. We don't shy away from saying so we want to help you. You are government employees, you serve the government, you will have to tell us how can we help. We'll continue there.
And what we have understood is that having held that court cannot issue a mandamus for grant of central DA Now the court has granted it, according to them, court has granted the same by applying ACPI. That is the trust. That is what their submission is.
Correct.
Having said that, it can't do, they have done it, the High Court and the Tribunal, by applying ACPI,
That's the point.
But according to us, what the High Court and the Tribunal.
And according to you and the High Court, ACPI, the application of this, what is this, ACPI?
Yes.
AICP is inbuilt in 3C.
Inbuilt the rule.
Inbuilt in 3. That is your case.
Yes, and it is from time.
Court has not applied any alien formula. It is inbuilt in 3C3. That is what your case.
Yes.
Their case is the rule makes it static. We say.
We can't be more clearer than this.
Correct.
As of now, the task is not as simple.
We are testing us whether we have understood.
These are very fair questions to be answered.
Well, there's only one aspect I want to say. Any order of your lordships in this context is going to impact all states in it.
All states
Kindly have.
who have not chosen centrally.
I'm sorry.
All states who have not chosen centrally.
And therefore,
Not all.
modification, they will be deeply interested in this issue. That's what I'm saying. Maybe your lordships might think in terms of actually hearing them, because this impacts them directly.
We certainly consider.
It's something very important.
We certainly consider.
Yes, sir.
Mr. Sibbal, it's a very valuable suggestion.
That's right.
We'll consider.
Yes.
We'll ponder over it.
Yes, sir.
Definitely tomorrow
Because
we are.
the federal structure is
In fact, no, in the morning only we said, yesterday we said, we're going to have all India panel.
exactly. It's not just a West Bengal matter.
Correct.
Your every case is pan India, Mr. Sibbal.
We are confined to our own state rules anyway.
Just accept that I don't have any impact pan India.
No, can't say that.
I wish I had. but-
Yes, one more aspect, because if I may just point out.
Confined to the
In a-
state rules.
In our application, which we had made, we have given certain figures, because the fiscal aspect is something which your lordships have stressed. As to the extent of burden it will.
36,000 crore.
Yes, and the extent of burden that will fall on us. But your lordship may just bear in mind in page 5 onwards of that application, because we have given figures.
Mr. Singhvi, in
But
fact,
any
has said
ancillary questions would come if there is this.
1 minute, sir, please, we have not finished. We have not called upon you, sir. But nonetheless, we have told you the difficulty which is there. If you read the code by now. So therefore, we can't be more candid in this.
That's
We want to help you. Tell us how best we can help you.
That's true. We have also tried to put that assist your lordship at that exchange.
Obliged.
Page 4 onwards of my application, I gave all those figures.
Tomorrow.
Influence.
It's no problem.